Recording in progress.
Morning, Chair. Chair. Morning, Adam. Can you hear me?
I can hear you, Eddie.
Okay. Good morning, Chair.
Morning.
Morning, Chair. Yes, it's 9 o'clock. We do have Deputy Minister DG in the meeting and also
Good
State
morning.
Law Advisor. Yeah. So we can start with the meeting, Chair.
Good morning.
Morning, Chair. Yes, I can hear you. Morning, Chair.
Eddie, I think we can hear you and we can hear the chair, but I'm not sure if he can hear us.
Yeah, that's what I'm thinking. He might not hear us. Chairperson, can you hear us? Chair?
Morning. Can you hear me?
Yes, Chair, we can hear you. Can you hear us?
Can you hear me?
Yes, we can hear you, Chair. Chairperson?
Morning.
Morning, Chair, we can hear you. We can hear you. I can see you as well.
Morning.
Morning, Chair. Can hear you.
Morning.
Morning, Chair.
Good morning, Chair. And good morning, members.
Good morning, DM.
Morning, DM. Morning, Chair. Morning, members.
Morning, everyone.
Morning. Chairperson, can
Morning,
you hear us?
everyone.
Everyone, good morning.
It looks like he has got connection problems. Let me just give him a call.
Morning. Can you hear me?
Yes, Chairperson, we can hear you.
Can you hear us, Chair?
Looks like he can't hear us.
Morning. Can you hear me?
We can hear you, Chair. Can you hear us?
Yes, Chair, we can hear you, but it looks like you cannot hear us.
Eddie, have you tried to phone the chairperson to and try and assist him? Eddie?
Yes, I just called him now. He said we'll just move around them. Probably it's his network connection.
Would this suggest that he leaves and rejoins and see if that helps?
Morning, members, if we can give the chairperson time to reconnect again, he has disconnected. He's trying to get a better spot.
Eddie, can you please allow me sharing rights for the first two items?
Chair is back.
Chairperson? Morning, Chair, can you hear me?
Yes, I can hear you.
Oh, okay. No, I think you're okay now. We can hear you as well.
Can you hear me now?
Yeah, we can hear you. Chairperson? Chairperson, we can hear you. Can you hear me?
Okay, can you hear me now?
Yes, I can hear you. Chairperson, I can hear you.
Can you hear me?
Yeah, I can hear you.
Mr. Matonzi?
Chairperson? Chairperson?
Morning, colleagues.
Good morning.
Morning, Acting Chair.
Yes, so the chairperson is still struggling with the connection. I think,
Morning, can you hear me?
oh, yes, Chair, we can hear you.
Chair, can you hear us?
I just spoke to him on the phone now. It looks like he's having trouble connecting. So, but he was suggesting if maybe we can get Memodisa because she just joined now to proceed with the meeting while he's trying to connect.
Okay, is Memodisa here? Then she can proceed with operating the meeting.
Yes, she just joined now. Memodisa,
Okay.
chairperson is struggling to join the meeting. We can hear him, but he cannot hear us. So he have asked that no, you proceed with the meeting while he's trying to reconnect.
Yeah. Chair. Eddie, can I just request that we rename device H06178693 to DDG Connie Moite, please?
Memodisa? Memodisa?
Eddie, is she here?
Yeah, she just joined.
Can you
the
hear me now?
meeting. Yes, who can hear you, Chair?
Can you hear us, Chair?
Hi, Eddie. Chair has requested that Honorable Bombani start in the meantime.
Oh, okay.
Thanks.
Yeah. All right. Mr. Ngubane?
Yes, Eddie.
Yes, I think you will have to, he has requested that you start with the meeting because I think also Memodisa, she cannot hear me.
Okay, all right. I think we will
I'm
start.
here, Eddie. I can. Oh, okay.
Go ahead, Mr. Ngubane.
Okay, I think I hear Memodisa is speaking in the background. So I think colleagues, we can start. DM and secretary, we will start then. I think the chair will find us as we progress with the meeting.
Yes, Mr. Ngubane. So if you can go ahead, or you want to defer this to Ms. Modise if she can able to hear us.
Check with her. Otherwise, let's start. The agenda has been displayed. The issues that we'll speak about today. Check with her if she can hear, because I heard her speak in the background.
Ms. Modise, can you hear me?
Yes, I can hear you, Eddie. Can you hear me?
Yeah, I can hear you. I think we can all hear you. And then chairperson is struggling to connect. We can hear him, but he cannot hear us. So he has requested that either you or Mr. Ngubane proceed with the meeting while he's trying to rejoin. Yes, the agenda over to you.
Okay, no, thank you very much. Colleagues, let me take this opportunity and greet the DM in the meeting. I'm not sure if the minister here, the DG and the collective.
Okay, Memodisa seems to be struggling.
We have an
Mr. Ngubane, Memodisa was proceeding. I'm not sure if you're having difficulties hearing her.
Okay, now she can proceed, yeah.
Yeah, okay.
Seems like she has been cut off as well.
Yeah,
Brian,
she's
can't we take maybe 15 minutes to fix this technical issues and then come back? It's my proposal.
Yeah, I think Chairperson has also requested that if either Mem Dise or Mr. Ngubane can chair the meeting while he's trying to connect, so that we don't delay.
Colleagues, I think let's proceed. The chair, Member Dise, will find us proceeding with the meeting. Eddie, we've displayed the agenda. Is there any additions or amendment? Can we get a mover and a second of the agenda so that Eddie, the chair, will come in later with the welcome and opening, and then Eddie, you will then give us the apologies and if there are any. Can we move for the adoption of the agenda first?
The agenda is fine.
Okay. From my side, colleagues, I wanted to add the issue of on the agenda. If colleagues agree with me that we add an item to talk about the Concord scrapping of Section 6.1 of Citizenship Act. Is that possible that we can add that item as well on the agenda?
Chair, I think there's a report. There's a report as part of the agenda, if I'm not mistaken. There's a report on that court case, that court judgment.
Is there a report, Eddie?
Yes, it was sent yesterday. In fact, it's on the agenda. If you check on item agenda number 8, briefing by the department on the Constitutional Court judgment on citizenship, is there.
Okay, all right. No, thank you so much. So I think then we are covered. Then there it is on the consent. Can we then move for the adoption? Honorable Ross has moved. Is there a seconder?
I moved. I'm the seconder.
Okay. Ms. Honorable Mtolo has seconded the agenda. And then the chair will come on it, opening and welcome. Eddie, take us on item number 2 on apologies.
Yes, Chair. The apology will be that of Ms. Mtambe. As I reported last week, she said she would be away for about a month. So I'll have to keep reporting her apology until she comes back. Then the other apology is that of the minister who's outside of the country. Those are the only 2 apologies I have. Thanks, Chair. Over to you.
Okay, thank you very much, Eddie. And then we come to the item number 3. Content advisor will then brief us on that the criteria. Hello?
Yes, Chair, noted.
Yeah, you will brief us on item number 3.
Yes, Chair.
On that legal aid board item, so you can proceed on that.
Thank you, Acting Chair. I must indicate that we did some desktop research on these 2 items. Also got feedback from NGOs that deal with these matters. We also requested the department for response, but it hadn't arrived by yesterday evening. So this is in the absence of the feedback from the department. So they are, however, in the meeting, so they can perhaps respond if there are any gaps or errors in our what we found in our desktop and NGO research. Just to indicate that the rights of migrants in general are protected by the Constitution, in the sense that Section 35 lays a foundation for the rights of arrest, detained, and accused persons, including the right to remain silent and to be brought before a court within 48 hours. And they also have the right to choose to consult a legal practitioner, to be informed promptly, and to have the legal practitioner assigned to them by the state at the expense of the state if substantial injustice would result, and to be informed of this right promptly. Section 35 elaborates that the rights of every accused person on trial includes the right to be represented by a legal practitioner of their choice, or have one assigned by the state. These constitutional guarantees are not limited to South African citizens, but extend to everyone within the Republic's borders, including foreign nationals and asylum seekers. This principle of equity before the law ensures that these vulnerable groups are entitled to the same fundamental rights and fundamental justice, including the right to access legal aid. Secondly, the Legal Aid South Africa Act of 2014 outlined specific processes considered that a court must follow when directing that a person in a criminal proceeding be provided with legal representation at state expense. It emphasizes that such directives are not automatic and are subject to a structured evaluation process involving both the court and the Legal Aid South Africa. A court in a criminal proceeding may only direct that a person be provided with legal representation at the state expense if that person is taken into account, if the court has taken into account that the personal circumstance of the person concerned, the nature and gravity of the charge the person is tied to, and whether any other legal representation at state expense is available or has been provided, and any other factor which, in the opinion of the court, should be taken into account. The regulations 9 of that act indicate that the legal aid will consider providing assistance only if the case shows good prospects of success, meaning there is a reasonable chance of winning the case, and good prospects for enforcement, indicating the ability to effectively implement any court order would be obtained. And additionally, there must be available resources which are determined based on a written merit report that assesses whether assisting the case aligns with the organization's capacity and priority. Regulation 19 on asylum seekers is that they be granted to legal aid applicants who seek asylum in the Republic and who intend to apply for asylum in terms of the Refugees Act. And it's not necessary for them to even be in their country physically to apply for this, but as long as they physically present at the date on when they apply for the legal aid. So they might leave and still be applied that legal assistance. Regulation 23.6, the legal aid may be granted to an unaccompanied foreign child it's contemplated in the Refugees Act, where it is required to protect the best interests of that child and if substantial injustice would otherwise result. And then in terms of the Refugees Act, referred to above, provides specific legal framework for the protection of asylum seekers. The cornerstone of that is non-refoulement, which prohibits the refusal of entry or expulsion or extradition or return of a person to any country where they may be subject to persecution or have their life put in danger. Holding a section 20 valid section 22 asylum or 24 refugee permit should in principle protect individuals from detention or deportation under the Immigration Act. Furthermore, the Act ensures that asylum seekers have all the rights outlined in the Constitution, except those specifically reserved for citizens such as voting. This includes the right to not be unlawfully arrested, detained, or deported, reinforcing their entitlement to fundamental rights, including access to legal aid when detained. However, despite these protections, reports indicate that documented asylum seekers and refugees are still sometimes detained, suggesting a disconnect between the legal framework and its practical implementation. The Immigration Act of 2002 provides a legal framework for the rest of illegal foreigners pending deportation, which is precisely the aspect that we're dealing with in the current amendment. The Act defines an illegal foreigner as a person who is in the Republic in contravention of the Act and who does not hold a valid permit or visa. Immigration officers are authorized to arrest without a warrant any person reasonably suspected of being an illegal foreigner. The Act stipulates that the detained individuals must be notified in writing of the decision to deport them and of their right to appeal. Furthermore, detainees can request at any time that an officer seek confirmation of their detention for deportation from a court warrant. And if a warrant is not issued within 48 hours of this request, the foreigner must be released immediately. The Act also provides that upon arrest or immediately thereafter, detainees must be informed of their rights, if possible, practical, and in a language they understand, including the right to legal assistance. Despite this legal obligation, the effective realization of this right can be hindered by various practical challenges such as lack of awareness, language barriers, lack of availability of translators, and limited access to legal services. The criteria for the eligibility for criteria for legal aid is that certain categories of individuals automatically qualify for legal aid regardless of their financial situation. In criminal cases, children under the age of 18 automatically qualify for legal aid and do not have to undergo a means test. This provision applies to all children within South Africa, irrespective of their nationality or immigration status, underscoring the state's commitment to safeguarding the rights of minors. Provisions that allow the organization to grant legal aid if it is likely that any applicant will suffer substantial injustice without legal representation. This is particularly relevant for detained individuals in criminal trials who cannot afford their own legal representation. The regulations specify that substantial injustice might occur if the detained person cannot afford legal representation and faces the possibility of a severe penalty. Detainees can also attempt to contact Legal Aid South Africa directly through their toll-free advice line or by requesting assistance from non-governmental organizations to provide legal services to refugees and migrants, such as Lawyers for Human Rights. South African law places an obligation on authorities to inform detained individuals of their right to seek legal representation upon arrest or detention. This information should be provided promptly in a language that detainees understand. Detainees have the right to challenge the lawfulness of their detention before the court. This right is crucial in preventing arbitrary and unlawful detention and ensures that the state's power to detain individuals is subject to judicial oversight. The UNHCR, mostly through its implementing partners, provide legal assistance to asylum seekers to extend the reach of the legal aid services to this vulnerable population. Key organizations include Lawyers for Human Rights, the University of Cape Town Rights Unit, the Scalabrini Center, the Nelson Mandela University Rights Center, amongst others. UNHCR's partner organizations offer a range of services, including legal advice, representation in court, assistance with documentation issues, and intervention in detention cases. UNHCR also engages in detention monitoring to minimize the risk of rights violations and encourage authorities to improve detention conditions. Challenges for legal representation in more detail is that the situation is particularly acute for migrant populations such as asylum seekers and refugees. Several factors such as language barriers frequently impede the communication with legal practitioners and understanding of legal processes. Lack of familiarity with the South African legal system, both by the migrants and sometimes immigration officials, can leave non-nationals disempowered and unable to navigate the complexities of seeking legal assistance. Socioeconomic vulnerabilities, including poverty and lack of stable employment, often prevent them from affording private legal representation, while awareness and access to pro bono services or legal aid in South Africa may be limited or non-existent. The challenges are compounded in the context of immigration detention. The administrative nature of these detentions, while subject to constitutional safeguards and highlighted in the recent court decisions, can sometimes be perceived as less urgent in the allocation of already strained legal aid resources compared to criminal matters. This can leave detained asylum seekers and refugees in a precarious position, facing potential deportation, where the crucial legal support necessary to challenge the lawfulness of their decisions to present their claims for protection or appeal adverse decisions is impeded. There's also a disjunct between the services available in urban centers versus in the rural areas where there are less legal aid representatives in general. Moving on to specifically children, policy of migrant children, the DHA and the DST have been cooperating on a policy level that recognizes the vulnerability of undocumented migrants for a number of years, over a decade, and they seek to provide the necessary protection. The key policy development, including a national steering committee on unaccompanied and separated migrant children, established in 2015. This committee brings together various stakeholders to coordinate efforts in safeguarding the right of unaccompanied minors. Children on the Move program, launched by DSD, this initiative aims to improve access to integrated child protection services for undocumented and unaccompanied minors. The white paper on citizenship, immigration, and refugee protection also outlines the government's approach to managing migration, including provisions for the protection of undocumented children. Excuse me. The more specific mechanisms is that the DHA is supposed to refer matters to DSD or designated child protection officers for investigation and children's court inquiries. And they're supposed to provide identity documents like birth certificates to eligible children. DHA also assists in tracing biological parents of families, especially in the cases of abandoned children. DHA issues waivers for undocumented minors who lack birth certificates when leaving or entering the country. Part of social development is supposed to provide social support, psychosocial support, and aftercare to undocumented minors. And DHA and DST collaborate in child repatriation, ranging for requirements at ports of entry. The practical provisions include that have been partially implemented over several areas. Access to education has been revised to allow children of undocumented foreign nationals to enroll in South African schools without the need for identification documents, for instance. Birth registration efforts have been made to facilitate late registration of birth for undocumented migrants, recognizing the importance of legal identity. Child protection services, they divide by authorities, are placed in child and youth care centers under the supervision of social workers, ensuring their safety and well-being. So this is all in terms of the policy and regulations. The Department of Social Development have guidelines for social workers for reunification within the context of international social services, but this doesn't deal with documentation. There were also standard operating procedures developed by the Center for Child Law in 2023 for interdepartmental procedures on documenting unaccompanied separated children, but these have not been finalized or approved yet. And the draft standard operating procedures developed by UNHCR, DHA, NGOs, Department of Social Development in 2024 are with the DHA, but have not been signed off. This is according to our NGO sources. Asylum-seeking children have better procedures in place, but there's less clarity on other migrants other migrant children found in the country. The challenges for migrant children specifically are that the statistics on undocumented migrants are lacking, hindering the effective policy planning. There are documentation barriers, as mentioned. Many undocumented children face difficulties in obtaining legal documentation due to bureaucratic hurdles and lack of awareness. There's risk of exploitation, where the minors are vulnerable to such things as child labor and trafficking. To address these issues, the DHA and DSA continue to collaborate in developing and implementing policies that protect the rights of undocumented foreign children. These include placing children in youth and child care centers under the supervision of social workers until they can be reunited with their families or find alternative care. Social workers are doing their best to assist children to access schooling and other services, but struggle to access the DHA for documentation. And this was specifically mentioned about the Western case. I'm not familiar how effective this is in the rest of the country from the available information online. The NGOs experience that both departments end up deferring responsibility to the other, and there's a lack of understanding by practitioners of what the other department's laws specify. So this is what we've been able to gather from what is being practiced at present related to these two matters. Thank you, Chair. I hand over to you.
Mr.
Thank you,
Ngubane.
Mr. Solomon. Is the chair back?
Yes, I saw him. He's back.
Chair, we've been briefed by the content advisor on that legal aid board representation of undocumented foreign nationals. Lord Chair? Okay, Mr. Salmon, thanks.
Yes,
Thanks.
can you hear me now?
Yes, Chair, we can hear you. Chair, we can hear
Can you hear
loud
me?
and clear. Yeah.
I have changed all my gadgets, so I don't know what's the problem.
We can hear you.
Can you hear us, Chairperson?
It's muted at the moment. While he was speaking to us, it was muted.
Yeah. Okay, Mr. Salmon, I think thank you for the briefing. Do we have a legal aid board probably to add on what you've briefed us on, or your briefing is sufficient, Mr. Salmon, in relation to this matter?
Thank you, Chair. No, we were just asked to do desktop research on the matter. We didn't invite the Legal Aid Board. However, we did request that the department to confirm on these matters, and they can perhaps indicate if there's anything that they wish to add to what we've presented, or if there were any updates on the implementation, for instance, of the standard operating procedures. And I see a hand from the Deputy Minister.
Yes, yes. Dear?
Good morning, Chair, and greetings to all the members and the management from various areas. Just to confirm on this issue, Chair, we had not received a formal request to respond to these issues. I think on the last week's portfolio committee, the DDG for immigration was asked in the meeting and provided some response. But noting today that there is a need for us to formally respond to those issues, we will then draft a response and then send it through. Thank you.
Okay, thanks a lot, DM. We'll appreciate the response so that we know the status of this matter in relation to representation on Home Affairs as well. The side of the Home Affairs item. Anything you want to say, Mr. Salmon, so that we before we move to the next point you need to present, because I saw when you were presenting there was an intertwine between these 2 points.
No, Chair. Yes, I think it was just to inform members as we go forward to the debate on the immigration detention. It's the broader context that informs the amendment to the Immigration Act. So it's just to give an idea of what's happening. But yes, we would appreciate the update from the department on how this is practiced, being brought forward, or how this is being implemented. Thank you, Chair.
Definitely. We would really appreciate, because we saw when there were other, I think it's Somalian refugees, they were represented by a lawyer. So that's what we want to know, whether was that lawyer from the Legal Aid Board, or all those things will assist us, the response from the Home Affairs in highlighting the matter. And then, Mr. Salmon, on item number 4, the Home Affairs and Social Development collaboration on undocumented foreign children or minors?
Yes, Chair. I covered both items in one presentation. The first 2 items on the agenda.
Can you hear me, Chair?
Yes, Chair, we can hear you. Yeah. Chairperson? Okay, colleagues, Mr. Salmon has covered both items, the social development collaboration with the Home Affairs and the Legal Aid Board. Let's move to item number 5 on the committee deliberation on the immigration amendment bill.
Okay,
Chairperson. Yeah, carry on, Eddie, sorry.
No, I was saying Ms. Clara Williams will go through the document that was sent on Friday.
Okay. Okay, please, Ms. Clara.
Good morning, Chairperson, and good morning, honorable members. I'm just going to share my screen with you. If you can just give me a moment, please. Can you please indicate whether you can see my screen?
Yes.
Thank you. Thank you so much, Chairperson and honorable members. So with me in my office, I've got Daksha Kasan, also from the Constitutional and Legal Services Office. We were asked at the previous meeting to facilitate deliberations on the issues relating to the Immigration Amendment Bill, and we drafted this document to assist the committee in its deliberations on the bill. We would like to recommend that the committee considers the questions when deliberating possible further amendments to the Immigration Act by amending the Immigration Amendment Bill. So the first issue related to the appropriate instrument within which guidance should be provided to assist immigration officials to implement the interests of justice criterion. And here we would like to recommend that the committee should consider whether this guidance should be provided in, firstly, the Immigration Act, secondly, the regulations, or thirdly, the Departmental Standard Operating Procedures. Now, with regards to amendments in the Immigration Act itself, so that's the primary legislation, the bill should then be amended to list or provide this guidance, and such factors can then be developed with the assistance of the department. If the guidance is to be provided in the regulations, now that is subordinate legislation, which must be made by the minister, then we propose that Section 7 of the Act be amended to place an obligation on the minister to make these regulations providing such guidance. So the word may should be changed to must to place this obligation on the minister. And then we would also propose that Section 34(1) capital A sub A of the Act, as contained in the bill, must be amended further to provide that the immigration officer must take into account the prescribed factors when considering whether the interest of justice permit the detention or the release of the immigrant. The other option is that the guidance be provided in the Departmental Standard Operating Procedures, but here we would like to recommend that the committee just considers that this is an internal document. It is not a legal document. It is not published, and it is therefore not readily available or accessible to the public. Lastly, the SOPs are easily amendable without notice to the public. The second issue related to the rights in Section 35(2) of the Constitution, and here we would like to recommend that the committee should consider whether the bill, as per the findings in the Constitutional Court judgments, expressly provide that a detained foreigner be informed of the following: the reason for being detained, as referred to in Section 35(2)(a) of the Constitution, the right to choose and consult with a legal practitioner, Section 35(2)(b) of the Constitution, and the right to have a legal practitioner assigned by the state and at state expense if substantial injustice would otherwise result, as stipulated in Section 35(2)(c) of the Constitution. We would also like to recommend that the committee should consider whether the bill, as per the findings in the 2017 Constitutional Court judgment, expressly provide that representations by the detained foreigner may be either oral or written. And then lastly, with regards to the Section 35(2) rights, regarding the language in which the detainee should be informed, we recommend that the committee should consider whether the bill, as per the public submissions, should delete the caveat where possible, practicable, and available, or whether the committee is of the view that the department can justify or has justified the limitation on the right in Section 35(4) of the Constitution. The third issue relates to children. Here we would like to recommend that the committee considers whether it is satisfied that the manner in which children, now those will be unaccompanied or accompanied foreign children, are currently dealt with by the department as per their explanations and whether this is adequate and sufficient. And also whether the committee is satisfied that the legislation referred to by the Office of the Chief State Law Advisor sufficiently protects children. In other words, the Children's Act, but without a reference to that act in the Immigration Act. If the committee is not satisfied that children are adequately protected, then we would like to suggest that the committee considers whether there should be amendments relating to the issue of children, which then should be left for review of the white paper process that is currently being undertaken by the department, given that this was not an issue addressed in the Constitutional Court judgments. Alternatively, whether the bill should be amended as per the recommendations made by our office in its presentations to the committee. In other words, should the bill expressly provide for a definition of child and then also amend the references to minor in the Immigration Act, also provide for how unaccompanied migrant children should be managed and that they should be treated as children in need of care in terms of the Children's Act. And lastly, that it should provide that the detention of a child must only be used as a measure of last resort and that children should be detained for the shortest appropriate period of time and separately from adults. Thank you, Chair.
Thank you, Ms. Williams. Colleagues, that's the brief on the Immigration Amendment Bill. We can then deliberate on what has been presented together with all the other items that the content advisor presented. Is there any other hand on the matter? I see this. Is Mr. Ross? Anyone else? Okay, I see only those two hands. So I'll start with Mr. Ross. You can proceed.
Thank you, Chair, and thank you to all the presenters. Chair, I think it will be important before we have a sort of a more complete deliberation to have that feedback from the DHA, specifically with regards to social development and that dynamic of the interaction on undocumented foreign children or minors. I think it's very important that we have that. But I think, on some of the points, again, just to re-emphasize, I think the committee has previously indicated that we should try and stick to the issues addressed in the court judgment and then leave further matters for the white paper, since as the white paper is in the process and the overall amendment of immigration law is imminent. So specifically around the children's amendments, as has been mentioned at the end there, that the children's amendments really be considered further in that white paper. Then on the issue of should the interest of justice be in the bill or regulations, Chair, our view is that, again, the matter of Dawood versus Minister of Home Affairs is very instructive in this case. And it says that discretionary powers that affect fundamental rights there should be clear guidelines in the enabling statute. And so the committee should probably consider the interest of justice criteria being in the bill itself and not be left to the minister to determine what those should be. Our view is that this committee should receive the interests of justice. So the department of stakeholders should draw those up for us from their standard operating procedures, etc. And then we as a committee satisfy ourselves that they have met all the requirements for interest of justice, and then they be included in the bill and not be left to regulations that is then basically done separately from this committee. I think Section 35(2), in terms of being informed of rights, it is a fundamental right to be informed of your rights. The chairperson, I think this committee has also deliberated on the challenges of deleting the where possible practical. And so that remains a challenge in terms of requiring that a person can come and say, I require you to communicate with me in any language of my choosing, or communicate in any language of my choosing, and then it is up to the South African government to come and do that, to provide an interpreter in your language. So although the legal advisors have said, well, that can be done in writing, it provides a tremendous challenge. And what I would request is when the Department of Home Affairs comes back to us, that they just really also touch on this issue again, just in terms of what is practical. How does it practically work? I think we saw some comments from the department saying that often in their experience, these persons would come and they would be able to speak English just fine until they got to court. And then suddenly they couldn't speak English. And there was some obscure language that was then suddenly being spoken. And then the onus is on the department to go and find somebody. So I'll give you an example, Chair, and I'm wrapping up. The Kleinzia issue. It's a couple of years ago now, but there were over 700 Zamazamas that were arrested, and the vast majority of them were released because the department was unable to process them in time. And residents of the area, after all that effort to arrest and detain the Zamazamas, members of the community were reporting that they were literally seeing them walking down the road back to the mining areas to just go and continue their business. So you can imagine a scenario of a major operation like that. You've arrested 770 persons, and now you are forced to go through all the different languages and provide an interpreter for each and every one. So it is a tremendous challenge in terms of, yes, the individual right, the right to be informed of your right in your own language, the right to representation, etc. But yeah, there needs to be some sort of a limit. Otherwise, we're going to end up with scenarios where, I'm talking about a justifiable limit here. There you have 700 persons. You've got to process within 48 hours and provide each one with somebody in their own language. And if they come up with 2 or 3 obscure languages, how are you going to get the interpreter in? How are you going to resolve that in that amount of time? So Chair, there's still those two sides of this story. On whether the language requirement should be possible and practical. Thank you, Chair.
Thank you very much, Ross, Honorable Ross. I think that actually it's a mammoth task, as you mentioned, to manage this challenge that we're having that has been presented. Honorable Mohale, thank you.
Thank you, Chair. Can you hear me?
Yes,
Hello?
yes, we can hear you.
No, thanks, Chair. Mine is very brief. Just clarity on that regulation 19. So how practically it would work, where legal aid needs to be provided for persons who intend to apply for asylum. So like, practically, how does it work? Does it mean that if a person then gets arrested and say, no, I intend to apply for asylum, then that person would get legal representation? Just clarity on. Thank you.
Thank you, Honorable Mohale. Ms. Mtolo?
Thank you, Chair. Greetings to honorable members and all departments. Mine, Chair, is a question. Does the Immigration Amendment Bill ensure people in immigration detention can get a lawyer, including free legal help if needed? How will this work in reality? Is that all, Chair? Thank you very much.
Thanks, Ms. Mtolo. Ms. Williams, I think those were the input from members. concerns as well with the especially the picture painted by Honorable Ross on if it's about over 700, all of them. Some are from Mozambique, some are from everywhere. How will that be handled? Ms. Williams, you want to assist on responding to some of these questions?
Yes, thank you so much, Chair. With regards to the remarks made by Honorable Roos, perhaps we should just indicate again that the department should justify the limitation of the rights as set out in the Constitution. And that is also why we indicated in our document that the committee should consider what those justifications are that are provided by the department and then make a decision whether it feels that it is justified. Because Section 36 of the Constitution does allow for limitations of the rights in the Bill of Rights. So we are simply saying that we understand that those rights can be limited, and we recommend that the committee considers the justification provided by the department. And then if the committee is of the view that that limitation is justified, then a further amendment to the Act would not be necessary in that respect. And then with regards to the question by Honorable Mtolo, again, in terms of the Constitution, the detained illegal foreigners do have the right to legal aid or legal representation of that person's choice. How this works in reality, we cannot really indicate. The department is best suited to indicate how this would work practically. But again, it is a right that is set out in the Constitution, and it also applies to illegal immigrants, not only citizens. And again, the question as to justification for limitation is something that we suggest the committee should consider. Thank you, Chair.
Thank you. Thank you, Ms. Williams. So I think that's the response, colleagues. As soon as everyone is inside the country, they have all the rights that they deserve on our Constitution. So that's a challenge. Have all the questions been addressed correctly, colleagues?
Yes, they have.
You covered Ross and Ms. Honorable Mohale as well?
Yeah, I'm fine, Chair.
You're fine. And Ms. Ntolo, you're fine also, right?
Yes, Chair.
Okay, all right. Colleagues, I think with that presentation and deliberation, then we will move to the item number 6, where we'll be briefed by the Department of Home Affairs on the counter-corruption and security services on the work that they've done to curb the corruption in the Department of Home Affairs. I don't know, Eddie, it's that the DDG will brief us on that. And the minister is here as well.
Chairperson, there's a hand from Ms. Williams from Parliament.
Yes, Ms. Williams?
Yeah.
Chairperson, can we be excused?
I think so. I think you've done your presentation. I think you can be excused. DM?
No, thank you, Chair. As just a means of introduction of the item, I have with me the DG Tommy Makode and also the DG Moyete, who is responsible for counter-corruption and security services. I also have Mr. Tulani Mavuso, who is the DDG for operations, as well as Advocate Malakate, who will take us through the presentation on the implication on how we are dealing with the Concord judgment. But as means of introduction of the presentation on counter-corruption and security services, it's just to indicate, Chair, that we are presenting on the work that is being done by the Unit of Counter-Corruption and Security Services within the Department of Home Affairs For us, this is a very important unit within the organization. It does not just deal with the issue of internal security or corruption issues, but we look at broader issues which also involve the external environment, which seeks to corrupt our own internal environment. And that is why you find that we don't just handle cases pertaining to employees only. We will present on the organizational structure, Chair, of which in its center, our key concern is the issue of resources for the funding of the positions. We are waiting for the budget impasse issue to be resolved so that we can know where we stand with regard to the funding of some of the positions. But that will become much clearer in terms of our concerns when we present the organizational structure. We'll also take you through the overall arcing strategy, which is what informs the work and how we approach our work when dealing with the counter-corruption and security services. Also take you through a highlight in terms of as means of showing you the impact that we've made over the past. So we'll take you through the APP as well as the AOP, which will then reflect somehow on the performance of the unit. And we'll also display how we use data analysis to inform our work. We have been very clear that we are moving towards building a digital-first Home Affairs. So this unit will also be leveraging on technology as well as data analysis, but that will be displayed further in the presentation, and we'll give you the highlights of the criminal cases as well as convictions as well as arrests, because it's a complete cycle that this unit has to go through. We firstly have to make sure their arrest cases are opened and ultimately to the level of convictions, and then give you a highlight of specific projects that are under investigation, and some of them where we will have had success, some like the photo swap issues, the SIU projects we are dealing with, the marriages of convenience, which are really starting to pick up now. They might have happened in the way in the past, but they are now picking up when people no longer have disagreements. I think we are highlighting that one of the cases that we will have received from the portfolio committee has some highlights of these marriages of convenience, but we will respond to it in more detail, as well as the response to corruption and various special assignments. As I've indicated, I have the DG, and the DG Moite will then lead us through the presentation, Chair. Thank you.
Thank you very much, Minister, Deputy Minister, about that briefing. I think it's very crucial. That department is a heartbeat of Home Affairs that will assist us to turn around most of the happenings at Home Affairs. Thank you so much. The DDG.
Good morning, members of the Portfolio Committee, Deputy Minister, DG of the department. I would ask, thank you so much for the lighting of the presentation. On slide 2, I think on slide 2, DM has really outlined the presentation, has outlined what we are going to do on this one, and we can go to slide 3. The slides are not moving on my sides. Can we please go to sorry, the slides are not moving on my sides. However, on slide 4, I'll be taking the Portfolio Committee through the purpose, which is really to outline what we are doing. We'll be talking to the structure, the strategy, and successes of the branch. And on the slide 5, that is mainly the legislative framework that we are using to go really about conducting our work. So I'll skip this one, and we can directly go to slide 7. Slide 7 talks about the structure of the branch. We are showing there that the posts that are filled, within the directorate. I think slide 8 will be clearer. We can go to slide 8. On slide 8, it shows clearly the number of total number of posts on the post establishment, which is 415. It shows the number of posts filled, it's 122. It shows the number of unfunded posts, 289, and number of vacant funded posts. We have 4 posts, and the branch is currently operating at 28% of its post establishment, which is really quite heavy on the officials that are doing the work. We can go to slide 10. Slide 10 really is the budget. The budget is outlined there, and we are saying there that the branch operational expenditure percentage is for the past reporting period was 78.1%, which is lower as compared to ideal percentage. The underspending of operational budget is due to less traveling of officials in the entire 2024-25 financial year, which had to do with the strict adherence to cost containment measures. The branch financial performance for 1st April to 31st March 2025 excludes the expenditure for fiscal security, contractual obligation, and self-financing. That is where we are really bleeding. I think we will show it as we go with the other slides. We can go to slide 11. The branch counter-corruption and security services developed several internal policies: security policy, vetting policy, investigation policy, reporting of unethical behavior, misconduct, and corruption. And we also have the fraud prevention policy and plan to ensure that all employees and stakeholders are made aware of the department's overall anti-fraud and corruption strategies. We can go to slide 12. Slide 12, which really talks about the pillars that we are following. The department counter-corruption and fraud prevention strategy was developed to effectively manage the fraud and corruption risk which the department is facing or can be exposed to in the course of its operation. The strategy is anchored on 4 pillars as depicted on this figure. CCS is responsible for the first 3 pillars: prevention, detection, and investigations. The 4th pillar, which is resolution prosecution, resides with employee engagement and other law enforcement agencies. That is where, after investigation, we do not conduct disciplinary inquiries. We refer to our employee engagement, which is within the HR, and on cases that need fraud to be further investigated, we refer to the South African Police Services. So the South African Police Services has been really the most integral part of what we do, especially the DPCI. We can go to slide 13. Slide 13 talks to the prevention. It shows there that on prevention, that is where we are conducting awareness and training for DHA staff and members of the public. Initiatives include fraud, corruption, and ethics awareness campaigns. We display posters, we send email alerts. On the preventative security, physical information and personal security, which is vetting. The aforementioned processes is done to protect the department from security risk by having officials and service providers vetted, conducting threat and risk assessments to identify, analyze, and evaluate potential threats and vulnerabilities that could harm the departments and security systems, and to provide mitigating strategies. Then we also have the detection section, which falls under the prevention pillar. And in this one, we conduct business processes continuously to review, identify possible vulnerabilities to fraud and corruption and security breaches, and to recommend mitigating strategies for implementation. Data is being analyzed from various systems. Documents and reports are analyzed in order to identify emerging trends, patterns, and possible fraud and corruption risk on our DHA processes. Then we can go to slide 14. Slide 14 is the third pillar of our of the strategy. Is the investigations. Here, internal investigations focuses on transgressions perpetrated by DHA officials. With the assistance of the analysis team, the branch is also able to conduct proactive investigations. I think as members of the portfolio committee are aware that when we were given 12 positions during 2023, for those positions, we ensured that we appoint analysts. We appointed analysts, and the directorate analysis was also activated to ensure that we work on the proactive side of investigations, because at the time we only had investigations, so we were really reactive in what we were doing. For now, we want to emphasize mainly on preventing rather than just investigating. Also on the space, a multidisciplinary approach is always invoked where the nature of matters under investigation warrants the involvement of other law enforcement agencies. And resolution, that is the fourth pillar, the pillar that I said resides within employee engagement and law enforcement agencies. We can go to slide 15, slide 16, where we are going to talk about the APP targets for 2024-25. Under the prevention, the target that we had there, we had to review 16 business processes with the aim of identifying corruption vulnerabilities and gaps within the business processes, and to recommend mitigating strategies to eliminate opportunities for officials to commit fraud and corruption. And we were doing 4 business processes per quarter, and we were able to achieve this target. And it shows there what we were doing. We worked on the spousal, critical, general visas and work and business visas. That's the process we evaluated. When we conduct this evaluation, we would have been advised by the trend analysis, where we see that a particular phenomenon is that we receive a lot of cases on that business process. So we go through that business process to check why are corrupt elements able to infiltrate that business process. So then we come up with mitigating strategies to close the identified loophole. And we also look at birth registrations at health facilities. We also look at death registrations, MAD-ID cards, late registration of birth and marriages between SA citizens and foreign nationals. And target on investigations, it was 80% of reported cases on fraud and corruption to be finalized within 90 working days. And on this one, 83.9% of reported cases on fraud and corruption were investigated and finalized within 90 working days. The target was achieved. And we were on security side, we had to do 40 threat and risk assessments, and 50 were conducted, which was an overachievement. And also we had to conduct vetting for our officials. We had to do 400 files. We conducted 449. The breakdown is there. We can go to slide 16. Slide 16 is where we now talking about AOP targets for the 2024-25. And on the AOP target, because we said there that we were doing 80% of cases to be investigated within 90 working days as an APP. We took the remainder, we said the remainder of the cases, 20% that we could not investigate that side. We ensured that we bring that target now to AOP so that we follow up on those cases. Now on these backlog cases, the 20% that was there, 64% of these cases were finalized within 90 working days. And on this base, we really do not have backlog. We are having around 7 cases, which is backlog from the previous quarters. And 60 awareness initiatives conducted, 79 awareness were conducted, and 4 trend analysis reports were submitted for the financial year. The trend analysis is the one that we use to see the pattern of corruption and the modus operandi that is being used. And on the for TRAs, we had to do 40 offices as follow-up, and we conducted 46. And we had a target of doing 40 evacuation drills to ensure that our offices are safe for the officials, and we really overachieved on this. We had 62 evaluation drills conducted, and on this one, really, it is the support of the municipalities. We were able to establish good working relationship with municipalities in all provinces, because on this one, municipalities are a very important stakeholder. 40 security awareness and training sessions held. We did 57 security awareness and training sessions. And we had to have 40 functional security committees that were held at head office and provinces to ensure that our offices understand the security. On this one, we could not achieve this target. This is the only target under AOP that we did not achieve. For the first quarter, really, we struggled to ensure that the committees are formed, until where head office had to really assist the provinces with ensuring that the committee, functional security committees were formed and meetings were held. So we had 33 instead of the 40. Then we can move to slide 18, slide 19. Slide 19, it shows outcomes of cases registered for investigation for the past 3 years. For 2022-23, we received 234 cases. The referrals and cases that were closed due to lack of evidence were 139. And then cases referred to employee engagement were 95. For 2023-24, we saw an increase there. We received 265 cases, and closures and referrals were 157. Referred for misconduct was 108. 2024-25, another increase there, 306, and referrals 194. And referred to employee engagement were 112. And we're showing there that for 2022-23, it involved 116 officials, 23-24, 147 officials, 24-25, 164 officials that were referred for further processing. And we are saying there that for the past 3 years, cases that have been investigated was 805. We can go to slide 20. Slide 20 shows officials referred to EE. What it really shows that prevalent transgressions investigated for the past 3 years pertain to green barcode and identity documents, smart ID cards, and unlawful registration of births. Those were the cases that we dealt with, which was quite higher. And we are saying there that business process reviews are currently underway in Q1 of the 2025-26 financial year to address vulnerabilities identified. And we can go to slide 21. These are transgressions under immigration services. For 2024-25, cases relating to visas were 10. After analyzing for over 24,000 records, 17 officials have been identified for irregular processing and unlawful issuance of study visas. 4 DHA officials and 2 officials from the Department of International Relations and Cooperation, DIRCO, were also charged in connection with visa-related corruption in Beijing, Accra, and Tunis. These officials are also being investigated by the Special Investigating Unit. After investigating these studied visas, analyzing, investigating, we referred the cases to the relevant, and one of the referrals was to SIU, and some of these cases really were referred to employee engagement and further referred to CJV, for CJV to also assist with the internal assisting employee engagement with disciplinary proceedings and transgressions. Other business unit, we have seen a steady increase in cases pertaining to financial misconduct. In most cases, officials failed to comply with Treasury regulations in that revenue collected was not banked daily and could also not be accounted for. Criminal cases were also opened against the officials identified. We can go to slide 22. Slide 22 talks about highlights of criminal cases, convictions, and arrests. For Q4 of 2024-25, 30 cases involving DHA officials, citizens, and foreign nationals were reported to the South African Police Services. In February 2025, a former immigration officer who was stationed at OR Tambo was sentenced in the Kempton Park Magistrate Court to a fine of 30,000 or 6 years imprisonment. The IO extorted money from a Thai national to enter the RSA. On 27 November 2024, a former adjudicator in the DHA permitting section was found guilty in the Pretoria Specialized Commercial Crime Court on 1 count of corruption. The official offered an investigator in the branch counter-corruption and security services an amount of 10,000 to hold the probe into his corrupt activities. And in this case, we requested DPCI to trap the official, and the official successfully paid the 10,000 to the official, and he was arrested on the spot, and the outcome of sentencing is awaited. In April 2024, an official who unlawfully issued birth certificate to foreign national for 1,000 was found guilty in the Guyana Specialized Commercial Crimes Court in Limpopo and sentenced to 14 years imprisonment. 19 November 2024, the Hawk Serious Corruption Investigation Unit in Nelspruit with counter-corruption arrested the DHA official Ms. Violet Veleni Mabena at her workplace, and she's currently out on bail. So the case is still ongoing. And 28 October 2024, we had an intelligence-driven operation with different teams, including immigration officers, counter-corruption, and the Hawks, where clandestine Home Affairs offices operating from a block of flats in Durban were searched. Several application forms, copies of identity documents, and electronic devices were confiscated. The SAPS are continuing with the case. And 24 October 2024, counter-corruption and immigration officers apprehended a suspect who was dealing with enabling SA documents unlawfully. And the official was, the person and the officials were charged. So we can go to slide 24. Slide 24 really talks about the Photoswap investigation project that the DHA counter-corruption and the Hawks DPCI worked on this project. A multidisciplinary approach together with law enforcement agencies was established. Investigation escalated to several other provinces, resulting in the arrest of several officials, SA citizens, and foreign nationals. So far, 27 officials were dismissed, of which 8 officials have been convicted and sentenced to an effective 197 years imprisonment. Convictions range between 4 years to 18 years. Criminal cases are also still pending. In one case, an official who was stationed at White River, also working on the passport photo swap, he was sentenced to 10 years imprisonment. And the asset forfeiture, the court ordered that he also pay the money that he received for bribe which was really a breakthrough, ensuring that we recover from the theft that happened. And slide 25 and 26 really talks about the dismissals. We can skip that and go to slide 27. Slide 27 really it talks about the cases that started on Mojalam, which is Marriage of Convenience project. On this one, SAP documentary uncovered evidence pertaining to marriages of convenience where foreign national offered South African women between 300 to 1,000 in exchange for marriage certificate. Counter-corruption investigated the matter, resulting in the arrest of the kingpin in Verena for allegedly arranging these marriages and possessing home affairs documents. What happened in this case when Mojalam approached the department investigations team? The women were claiming to have been married illegally. But when the investigators went through the records, we uncovered that the women were actually complicit because they signed fingerprints there, their biometrics were there on the forms, there were witnesses on the forms. And once we showed them that evidence, then that was when they started confessing to say no, they were actually paid. And I think the narrative from the program changed from being illegal marriages to where the program now is assisting the South African women with divorce, ensuring that they divorce from the spouses because it was proven that they were being paid to participate in these marriages of convenience. And one foreigner there was found to be working in collaboration with officials from departments, offices in Witbank and Johannesburg. 10 DHA officials from Witbank and Johannesburg offices were identified. 5 officials were dismissed for the misconduct, and 5 officials are currently facing disciplinary action. Criminal cases are still ongoing. A total of 28 foreign nationals implicated in fraudulent marriages were referred to the branch civic services to cancel the fraudulent marriages and the branch immigration services to investigate the status of foreigners in the country. We can go to slide 28. Slide 28 talks about the information that was received regarding allegations of rampant corruption at the Tshwane Refugee Reception Center and other refugee centers. We know that a proclamation was signed by the president to allow the SIU to investigate immigration officials for colluding with asylum seekers. And a multidisciplinary operation was executed, which led to the search and seizure of electronic evidence and documents for investigation purposes. The investigation is still ongoing. We have not yet received any feedback from SIU on this matter. Slide 29. Counter-corruption and security service received several allegations regarding the issuance of study visas, specifically concerning foreign nationals allegedly changing their visa status from visitors visas to study visas through fraudulent means. In response to these allegations, analysis was conducted which revealed several anomalies. The matter was subsequently referred to the Directorate Investigations for further investigation. In this case, when analysts, because now we have an analysis section, they are able to deal with quite a number of transactions. So after they analyze, then they refer to the sister directorate, which is investigation for further investigation. And when investigators investigated, a total of 17 individuals, officials were identified for further investigation, and the following findings were uncovered: that visas were issued without following the correct procedure. Verification of schools or institution was not conducted. Fraudulent bank statements and medical reports were submitted. Visas from the applicants' countries of origin were found to be fraudulent. Certain officials were found to be adjudicating visas for specific nationalities. So that was the finding. Several cases against officials were referred to employee engagement to institute disciplinary action, and immigration was also requested to cancel the documents that had been obtained through fraudulent means, and the case was also referred to SIU. And on slide 30, really is the investigations that we did at the mission in Beijing. An investigation to the matter uncovered the following irregularities in intercompany transfer. Visas were issued for non-existent South African companies. Fake employment offers were submitted by applicants and companies listed did not exist. The matter was referred to employee engagement and CJV for disciplinary measures, and the officials involved were dismissed. Slide 31, it's investigations relating to the Libya mission. The investigation revealed that 2 officials from DERCO were implicated on regular issuance of study visas without adhering to the departmental. 2 officials from DERCO were investigated, and the investigation report was referred to DERCO for DERCO to charge the officials, as the officials involved in this were DERCO officials. This case is still pending. And the slide 32 talks to the mission in Ghana. 2 officials from DERCO and DHA were implicated, and the matters were referred to both departments, employee engagement and CJV for disciplinary action. Subsequently, the officials were dismissed. And we can go to slide 34. On slide 34, really, we're talking about our analysis team, which is a flagship of the branch, which is what we are building. And we're saying there that the department has strengthened the use of big data analytics in identifying unscrupulous behavior. And because syndicates operated undetected and investigators and detection officers were unable to proactively detect their fraudulent activities using manual data. Some of the risks associated with sourcing reliable data was that the department systems are fragmented, information lying in different systems, which makes it impossible to get a helicopter view of or interpret the information. And because data was sourced manually and could really be open for manipulation. So to mitigate the risk, the department has introduced a powerful data analysis solution that auditors, business analysts, and fraud investigators use to assess and analyze data. It is an automated system using centralized data analytics results. This means the data is drawn from various DHA systems to analyze and map out fraudulent activities. It is a tool that assists with a proactive approach to early detect fraud and corruption when linked to the various DHA systems. It provides data integrity, which eliminates possibilities of manipulation of information, and the data from there is reliable and accurate. Data, raw data, is received straight from the source. So we have worked, in collaboration with our internal audit to ensure that we train our officials to be able to work on this tool. And the tool, really, we're working at ensuring that it's being linked to all DHA systems so that we can get real-time data. It is meant to draw big data from DHA system and process it to enable an automated analysis of results. The procurement process of enhancing the tool is underway. A service provider has been appointed to implement and train the analysts on the tool. The project is in 2 phases. The first phase has proved to be successful in linking the Arbitage tool to DHA systems. It is expected to be concluded in June and July, and training will continue. So the second phase will be initiated in 2026 to 27 financial year, which will include your HR and other processes. Remember, for us to go through this, it was the result of the Lubisi report where we saw that our systems were fragmented and we could not get real-time data. And now the team that we have of analysts are able now to work on this and ensure that we close the identified loopholes that were shown on the Lubisi report. So we can go to slide Slide 36 still talk to the big data analytics. We can pass that. So also on the prevention side, response to corruption, slide 37, we are talking about the initiatives that we are working on to raise awareness amongst employees, the public and stakeholders on an ongoing basis of what constitutes fraud and corruption and the standards of ethical conduct expected of them. And on this one, we're saying 79 awareness initiatives were conducted, 51 were internal and 28 were for external. So there we are just showing the type of campaigns that took place and the type of initiative. I think we can go to slide 38. Slide 38 really talks to vetting, and it depicts the categories of employees vetted and those not yet vetted within the department. It also reflects the respective levels of clearance, their status, which warrants reapplication of new applications. Remember, vetting takes 5 years, and every 5 years we have to continue to start the process afresh. So the stats are very clear there. We can go to slide 39. In addition, this unit conduct lifestyle audit guided by Regulation 22 of the Public Service Act. This is done under the auspices of the DPSA, wherein a framework and strategy was approved by the DG DPSA for the implementation of lifestyle audits in the public service. The DPSA initiates this process by designating salary levels within departments that need to complete declaration of business interests. To date, a total of 476 lifestyle audits have been concluded as per the breakdown below. 344 SMS members, 132 lower levels, ASD and level 10. The findings is that most of the lower level employees, ASDs, were found to be highly indebted and were subsequently referred to vetting. As for the SMS members, there is a significant improvement regarding disclosure of business interest. We can go to slide 41. That talks to special projects. On our special projects, DHA received information relating to the issuance of traffic register numbers at an office in Berkeley West in the Northern Cape. A traffic register number is really a number that is foreigners that is provided to foreigners to be in the country. It helps foreigners to be able to drive in the country, to acquire vehicles in the country. So we found that this process was being really being frauded by foreign national, outcome of the analysis, we saw that foreign nationals are using false identities during their stay in the Republic without verification from Home Affairs, which is the custodian of information on the legal status of everyone in the country. What happens here is that foreign national would go to the Department of Transport, produce a visa, produce an asylum seeker number, which is fraudulent. The paper will be fraudulent because there's no interface between Department of Transport and Home Affairs for the Transport Department to verify the visa that is submitted to the official. They just approved. And we found that there were a lot of those that were approved with fraudulent documents. Majority of, and when we analyzed, we found that majority of TRN holders did not appear on DHA systems due to fraudulent documents submitted when applying for TRNs. The Department of Transport, one of the recommendations was that the Department of Transport partner with DHA in order to establish a secure link for verification of the validity of identification documents used to apply for traffic register numbers. And we found that the traffic register numbers does not expire. So once a foreigner have applied for traffic register number, it does not expire. However, the permits, they do expire. So meaning that once a foreigner has got a traffic register number, he can use it perpetually to apply for license, register vehicles and do everything without coming back to Home Affairs. So process to date, the case was referred to there was engagement, there was a project of engaging with a Department of Transport to show them the findings of the report. And subsequently, the case was referred to SIU. The case had recommendations and everything so that SIU can help both departments to ensure that the documents, the driver's licenses and TRNs that were issued to the foreign nationals are withdrawn. So that was referred to SIU. And we can go to slide 42. Slide 42. All right, this is still has got to do with the TRN. I think we can move. This project has been referred to SIU. And one of the special projects we undertook was on the study visas. And anomalies in study visa issuing process were identified and referred, and directorate investigations investigated. The records that were looked at by the analysis team was 24,608. And the case was also referred to SIU and to CJV. And currently the investigations is ongoing, and the police were also provided with evidence with the project to ensure that they assist us with criminal prosecution of the identified officials. And slide 44. Slide 44 really talks to challenges and recommendations. We're talking there of insufficient budget allocation to honor contractual obligations. On this one, really, we're talking about the security space, where we are having serious challenges in terms of the budget in that space. And we know that there was no increase in the past 5 years, despite new offices being open. There is no price adjustment for the service providers, resulting in several litigations against DHA, which also lead to reputational damage. However, there are ongoing discussions with DDG Ops, DDG CCS, and the CFO to resolve funding challenges. And also in offices, we have a challenge of poor security due to outdated systems, resulting in increase in security incidents. Insufficient security personnel, we have shown there that we are having over 276 vacant posts, and most of these posts are also in the security space, lower levels. So we are really having a challenge. There's no way that we can say we can use DHA officials in all the offices, as we do not have. So currently we are operating with 1 guard per shift. And also we had a 50% reduction that happened. And this on its own compromises the safety and security of DHA asset. For January 2025 alone, there were 14 security incidents on the 12th and 13th of February. The client stormed Molopo and Byron building respectively in need of services. In the process, the safety and security of employees were threatened. We are saying that the department should really revise the security complement to cater for the security needs of each office as to enhance safety and security of the department. Continue to request additional funding necessary for maintenance of installation of security equipment as to enhance safety and security in departments. And we're really aware that there's no money. However, this is the section for us that is really showing us quite a lot of challenges. So if we can look at maybe filling posts so that we can install some of the security personnel, ensure that we use our own, that will be better. Or maybe find money somewhere to ensure that we are able to protect the department. Also capacity challenges with regard to personnel resulting in delay in the vetting of officials. Also in vetting, we also have capacity challenges. The clearance expire in every 5 years, and the directorate does not have enough capacity to keep up with the clearance that expire. Delays in the finalization of applications and issuance of security clearance certificate by SSA. Capacitate by filling vacant posts and signing of the MOU with SSA, which we are busy with. The MOU was really with the legal services of MOU. They were working on this. We are really working on this to ensure that we get results as quickly as we should. And also we are saying budget should be allocated realistically and based on the achievement of planned targets to ensure that we are able to keep up with the vetting process as required. We can go to slide, yeah. I think that is the last slide, and the request is for the portfolio committee to take note of the presentation and the recommendations outlined. Thank you, Chairperson.
Thank you very much, DDG Moitse. I think the chairperson's IT challenges have been sorted out. So I will then hand over to the chairperson. The chairperson, it was DDG Moitse who presented this critical department in the Home Affairs. That, remember, we all spoke about the Department on the Counter-Corruption and Security Services that is tasked to cap corruption and fraud activities within the Home Affairs. So this was her presentation currently. So I think she's done now, Chair. I think my comment, Chair, before I hand over to you, is that the Minister, we really commend, we even commended it before, this department, and says it's a very much good step in the right direction. And then we emphasize as well the need to properly budget it and properly capacitate it, and then make sure that everything that this department needs is given. And even to add, Minister and DDG, the comms team, this section of the Home Affairs is very much unknown, but it's a heartbeat of the Home Affairs. As before, when we were speaking about the other corruption that has been unearthed, and we didn't know that they came out to light because there was a background work, huge background work that was done by this department. I think somehow it needs to be beefed up with a proper comms team. As the DDG has said as well, the interfaces with other department is very crucial. And on the lifestyle audit as well, if DDG, and then we can start with mostly departments on the employees that are at the SCM level. You find SCM staff in the department, some of them have lifts in their home, some have escalators, but the person is earning around 15,000 rand. So these are all the things. I think the lifestyle audit as well will help in curbing all these foreign tendencies of employees that instead of servicing the country, they end up servicing themselves, as well as the integration with other intelligence department. I think from that nutshell, Chairperson, there is a hand from Mr. Mohale. I will hand over to you, Chair, so that you can take over from here and drive the meeting in the right direction. Thank you, Chairperson. Is the chair back then so that he can take over?
It looks like the system has kicked him out again.
How he said to me, everything is fine now. He's good to go.
Yeah, I'm just checking on his name. He's not on the system.
Oh, okay. All right. Okay. Let me then.
I just admitted him again now.
Okay.
Chair, can you hear us?
Yes.
Oh, okay. No. Mr. Ngubane, if you can just brief him and then hand over to him.
Okay, Chairperson, I've spoken length. I thought you were on online. I said I've commented on the DDG Moitse's presentation, and then there are hands related to the presentation that has been done by DDG Moitse. So I said, let me hand over to you so that you run the meeting.
thanks very much, Honorable Ngubane and all members of Parliament in attendance. I must apologize. I don't know what today is happening with all my gadgets, but at least I've managed to sort one or two issues. I've been following the meeting, even the first item. Unfortunately, I could not comment. And thanks, Honorable Ngubane, for facilitating this collective work. Can now invite the hands. I see there's the hand of Honorable Machi, Honorable Mukhale, Honorable Ruos, and I'm sure Honorable Ngubane want to take a bite, and Honorable Matapo, in that order, and Honorable Mutolo.
Thank you. Thank you, Chairperson. Thank you very much for the presenters, for the good work that the presentations that they've presented. So I also concur with Honorable Ngubane when it comes to concerning the additional of AMACOMs, so then the good work by the Home Affairs can be known to the people. Yes, we are happy. We used to see now officials being jailed or being arrested day by day. And the Home Affairs is doing the job, because most of the people, they used to complain about the corruption of the officials from our department, which is Home Affairs. As we used to say, Home Affairs is the heart of our country. And they also have got to appreciate also this issue of a life audit. It's very important, because it's where corrupt officials are seen. As my colleagues have indicated, that you only find out that a person is salary, is having a legally salary, but staying or living a high life of the high standard. And also, there are things, Chairperson, that we can say maybe Home Affairs, people are used to say Home Affairs is corrupt, others are saying they don't know their marriages, only to find out that they did. They were part of the arrangement of the marriage. There are papers there are documents where they've signed, and then now they wanted the Home Affairs to take them out from their marriages, of which they thought maybe they will enjoy, only to find out that after they were exchanged with the certificates and money, and that marriage, it's no longer the sweet or the chocolates that was awaited for. So now I'm very much pleased with the presentation, and for what they are doing to make a follow-up in order for Home Affairs to be set free from other things. Yes, because I don't want to continue for that Eastern Cape Mulelwa thing. I'll talk when it comes to that one. Thank you, Chairperson.
Thank you very much, Honorable Mukhale.
No, thank you very much, Honorable Chair, and welcome, Chair. Let me start off by thanking Memwitse for the good presentation. I'll just raise a couple of issues, Chair, that I picked up or noted from the presentation. But let me also start by acknowledging the good work that they are doing, despite some of the challenging conditions that she has already highlighted. But let me commend them for the good work that they are doing so far in turning around the very bad negative image that the Department of Home Affairs has
the perception that it's a department that is riddled with corruption. It's corrupt to the core. So I think the steps and the actions that are being taken to address the high levels of corruption within Home Affairs are very much welcome, and they are appreciated. However, I just want to register that, Chair, I am concerned with the issues of staffing, the lack of personnel, and how it hampers the work that needs to be done, and also the constraints in terms of traveling. I mean, we heard that the officials are not able to travel because of the cost-cutting measures that are being implemented by the department. And I think that should not be the case, Chairperson, because I believe how are you going to investigate incidents of corruption if your officials who are supposed to do the work are unable to travel to the sites and do the investigation and all of that? So I think something needs to be done in that regard to address that particular issue so that officials are able to travel and to go to places where these incidents of corruption are happening. And the second issue I want to raise, Chair, with regards to the investigations and the outcome. Firstly, I want to understand, when you charge these corrupt officials, I see you are only charging them with fraud and corruption and so on. Is it possible that we should maybe now consider charging these people with treason? Is it possible to start charging people with treason? Because the actions that some of these officials are involved in all honesty, Chairperson, they amount to treason, because they are, Home Affairs is a security department. It's a security department. It's a very critical department of our government. So it's very wrong, Chairperson, to, in my view, to just charge these corrupt officials with fraud and corruption and not add a charge of treason. Because like I've stated, that Home Affairs is a security department, and you will be bringing in people who are not supposed to be in South Africa, people who are here for nefarious activities, for terrorist actions or whatever, to spy on our government, to infiltrate our state and all of that. So the security concerns, Chairperson, are very much critical when we deal with these issues. So I would really urge that we should start to charge these corrupt officials with treason, Chairperson. That will act as a serious deterrence to would-be corrupt officials. And also, Chair, the issue that was pointed out of the ID swapping, I want to understand, in that particular incident, ID swapping and this fake marriages or marriages of convenience, who gets charged and who gets arrested in those circumstances? Because we have situations here where South African women are collaborating with foreign nationals to get married to them and for whatever reason, and then later on come and say they didn't know anything. It was a fake marriage arranged by Home Affairs. So I want to understand what happens in that situation. Do also the South African citizens who are aiding and abetting this corruption, are they also getting charged for their involvement, for their tacit support of these corrupt activities? And how many of such arrests have taken place in the previous financial year? So that's one issue that I think we will need clarity on. And lastly, Chair, the issue of this back room Home Affairs offices that are being set up in the CBDs and in the people's houses and flats. How many of these back room Home Affairs have they been able to identify? Because I believe there are many. It's not just the few that were just reported on there, but I believe there are many, Chair, because you have noted in the report that a lot of the illegal immigrants who are in the country are operating on fake documents. Somebody is producing those documents. There's somebody who's sitting, who's got a special operation to produce those documents. So how many of such backroom Home Affairs have they been able to identify and stop their activities? And also the trends. What are the trends that are emerging as they do their data analysis and investigations? What are the trends and the involvement of these syndicates in the corruption that is taking place in Home Affairs? And lastly, Chair, as I close, they noted that the low-level employees in Home Affairs are highly indebted. Low-level employees are highly in debt. So I want to understand, does the high level of debt also make them vulnerable to being approached by corrupt elements? And do they find that, such officials then get involved in corrupt activities because of the level of debt that, they have incurred in their lives? And what specific duties are these officials performing in the various Home Affairs offices across the country? Because I think it will also be important to know where they're operating, these officials, so that they are monitored. They should be monitored. People like that who are vulnerable, they should be monitored, because at any time they can be bribed, they can take money to do corrupt activities. And the fake documents that you are picking up with regards to the IDs and birth certificates, what happens to those documents? Do you then cancel them? And what happens to the individuals linked to those documents who came and asked or applied, requested for those documents? Thank you, Chair. I think that I'll stop there. Thank you, Chair.
Thank you, Honorable Mukhale. Honorable Matopo.
Thank you very much, Chair. Am I audible?
Yes, proceed.
Okay. Let me also take this opportunity to welcome the presentation and also acknowledge the work that has been done thus far in combating crime and corruption. Chair, on slide number 8, I just want to understand from the presenter that when they said unfunded posts, does this post have an allocation, a budget allocation or funding for salaries or operational support, or does these people volunteer So I just want to understand the term that's used, unfunded post in slide 8. Or are they employed without expectation of a salary? Or where does these salaries come from if it's not a budgeted area for posts? And another on the illegal marriages, Chair, I just want to highlight that we must take cognizance that not all cases should be classified as the victims were complicit. It's a known fact that there are other South African women who were married under false pretenses and who were married without their knowledge. On that very same note of the post, Chair, I would have loved if we could have been supplied with a comprehensive breakdown ratio in terms of race of these posts. And then on slide 38, which is presenting the vetted, where employees, how many employees are vetted and how many are still to be vetted by the State Security Agency. My request would be, one, can that be fast-tracked, Chair? Because we find ourselves vulnerable to crimes conducted by people who pose as subs officials, who are who have subs uniforms in their possession. And then you ask yourself, where did these people, your bogus subs on the road, stopping people, robbing people, hijacking people, and which is really putting the department in disrepute and just painting all the subs police with this bad brush. And the presenter has covered some of my other points in the challenges remarks in the challenges slide 44, where he has alluded to the remarks. That is all I would like to deposit, Chair. Thank you.
Thank you very much, Honorable Matapo. Honorable Roos.
Thank you, Chair, and welcome back. Chair, if I may start by wishing Honorable Ngubani a very happy birthday for today, and many more. Chair, this is a very comprehensive presentation, and clearly there's a lot going on in counter-corruption. And we welcome and congratulate the department on achieving all the APP targets and all but one of the AOP targets. And I think that functional security committees is an important one. So although 33 out of 40 were done, and we do accept the explanation, there is a thing of security guards running interference with queue management that this committee has discussed on many occasions previously. So my question really to the department in this regard is, are body cams being considered for persons that are doing queue management at these offices, and whether there are security guards that are doing queue management, and whether they would also have these? You might find that a lot of the corruption and money taking in order to influence queues would be resolved if this were put into place. Then, Chair, the budget hit it's a reality, and Home Affairs was a department that particularly took a big hit in terms of actually having its budget decreased, and not even just having a small increase, but having it decreased. And so we welcome the AI analysis team as sort of a force multiplier that will be able to assist with catching more persons involved in corruption. But I'm interested to see that more than half the cases were acquitted because there was no evidence. And I'd just like to understand what is going on here. I mean, are persons not required to provide some sort of prima facie evidence when lodging a complaint, or can they literally just say this official is corrupt, please investigate, and then there's no evidence? I just want to understand why are more than half the cases acquitted because there is no evidence. And then how did they get reported and accepted in the first place? And then it's good to see that perpetrators are being reported to police for criminal prosecution more and more. And Honorable Makhali is not far off the mark in terms of the impact of what is going on here, the impact of fraudulent documentation on innocent South Africans who now have their documents questioned and are denied visa-free entry into a lot of countries because there can be a perception on the security of the documents. So certainly it's critical to take a harder and harder stance. So we do note that there seem to be more and more of these cases that are reported for criminal prosecution. I'd like to touch on the statement that 17 officials were identified for irregular processing and unlawful issuance of study visas. And so it says that these officials are also being investigated by the SIU. So our question is, why must the SIU also investigate these persons that have already been investigated? And then let's say you've arrested and you've identified that these persons are irregularly processing these documents. So what happens to these people while the SIU investigates them? Do they continue in the department? Are they suspended on full pay? I just want to get an understanding of why persons that are already investigated by yourself are not subject to disciplinary processes and then handed over to the police for prosecution. Then there was some specific issues raised, and I noticed, for example, the persons at Beijing and the Ghana mission, the officials were dismissed, but it doesn't indicate that they were reported for a criminal sanction. So when officials are sanctioned by Home Affairs for being involved in corrupt activities related to visas, why are some reported to SAPS and why are some not? They're just dismissed and let go. I'd like to understand, is there different criteria here or is there something that is still coming? But Chair, overall, I think there's clearly an increase in investigations and the increase in arrests is welcomed. And we look forward to seeing the impact of the AI analysis team. Thank you, Chair.
Thank you very much, Honorable Ross. Honorable Mtolo.
Thank you, Chair. On the counter-corruption, as the ANC was strong urges the law enforcement agents to act without any favor or fear against anyone who fraudulently issue of acquire the Home Affairs identify document. And another question, we are concerned about the security service in Department of Home Affairs, where in some incidences, staff of Home Affairs are attacked by clients. What measures will be in place by the Department of Home Affairs to ensure adequate security in offices and those ensure the security of the staff, Home Affairs and the clients? On the matter of Tonyana matters, we welcome the steps taken by the Department of Home Affairs to resolve the challenging matter of Ms. Toyana. Thank you very much, Chair.
Thank you very much, Honorable Mtolo. Honorable Ngubane. Oh, sorry, Honorable Ngubane, I see the hand of Honorable Mukhale. Or is a legacy hand?
It's a legacy hand, Chair.
Okay, thank you. Honorable Ngubane.
Yeah, thank you very much, Chair. I commented earlier on in appreciation of the presentation, Chair, as well as, like we said before, that this department is a heartbeat of Home Affairs. And my plea and request as well, Chair, was from the Deputy Minister's side, that they pour all the resources required in this department so that it assists us, and to add on the comms team, Chair, that if it can be added up so that this department cannot be like it is now as an unknown section of the Home Affairs, but that is doing a great work. If it can be capacitated and be funded, and anywhere where minister probably they can shift funds to this entity so that it be able to to minimize all the wrongs that are going on at the Home Affairs. And its work needs to be known. At this stage, few people know about this section. But as I said, Chair, it's doing a great job, and we really appreciate the work that they are doing. We wish that they can keep it up and grow from strength to strength on what they're doing, so that we reduce these criminal activities that are happening on Home Affairs. Thank you, Chair.
Thank you very much, colleagues, and also appreciation of the work that has been demonstrated. And I think this report give a signal of good work since we have received this brief, DDG Mwete, on the collective work that you continuously do. I think what the committee may need to note, which is a matter of concern, is a budget that will impede on the work that this has been defined by DDG Mwete, and that will compromise the security status of the department. And I think that's one important area that we may need to take home. I think there's a highlight of weaknesses in relation to security measures in the department that also will empower the syndicates to strengthen their work both outside and within the department. And I think it is true that the work of the multidisciplinary team exposes that these syndicates are highly have a strong network within a department. And we must say that there are some of those of public servants that are doing a good work to service our people. And there are those that, as the report has outlined, that we must be grounding them, DDG Mwete, in terms of the tools used to confront these corrupt activities. The other point which I wanted to check also is to what extent is the department engaging with the missions in relation to documents that are issued fraudulently to students who are within our public institutions. What will be the status now that at least you have exposed such fraudulent documents that are issued to students, and the engagement with the mission? I fully agree with the Honorable Rose that it may be a duplicate work to submit for another process of investigation when you have satisfied yourselves with the tools that indeed this official has conducted corrupt activities. And I think the disciplinary process and the measures that need to be taken, it may take longer to also involve other institutions, whereas we know that collective law enforcement agencies must work together. But what are the thinking behind the department? Thanks very much. I will invite DDG Mwete to comment, and the DG and the Deputy Minister.
Thank you, Honorable Chairperson. I will start with the questions of Honorable Makali, which was talking about the staffing. The challenge with the staffing, I think on slide 8, it shows the structure post-establishment, that the structure is supposed to have 415 people in the structure. We are saying currently number of posts that are filled is 122, and posts that are not filled is the 289 that is there on slide 8. So we are saying the structure is not fully funded. So there is only a particular number that is 126 that is funded. So hence we are saying we are currently operating at 28% of the post establishments. And the constraint in terms of traveling for the previous financial year, we did not have quite a challenge with the budget. It's just that the officials were really trying to do things more differently in terms of being cost effective, doing more with what we have, and also the appointment of officials in provinces. Remember, when we got the 12 posts, we ensured that we also appoint investigators in provinces. So that minimized the traveling of head office officials to provinces. So that also helped. And when we charge corrupt officials, is it possible to charge them with treason? And we will look at this with the prosecution team, because what we advocate for now is integrated approach, where when we start investigations, we work with all law enforcement. For instance, there should be prosecutors on our team, there should be a DPCI team. So that is why on the photo swap process, we were able to be successful because it was a prosecution-driven investigation. Currently, we charged the main syndicate on this one with POCA Act, Prevention of Organized Crime Act, which was run as a project. Though project-driven investigations takes longer, however, they yield better results. So instead of treason, what I can say for now is that we have ventured into the POCA Act to ensure that we charge them as an enterprise in terms of the Prevention of Organized Crime Act. And marriages of convenience, who is charged, we ensure that we remember for DHA, we will charge our official and also support SAPS in terms of showing SAPS that the women that took part in this were complicit, and will also support SAPS in their investigations with all the documentation that we have that shows the signatures, the biometric, and the witnesses that were there during the marriage. So we support the SAPS in this process, and indeed, South African women are also charged because they were in most cases found to be complicit. However, in this, I've not prepared the stats for this, but we are sure that they are being charged. And trends, what are the trends? I think I have shown in one of the slides that the trends currently, it shows that there's a lot of demand for our identity documents and birth certificates. So the trend is that our officials will steal the dormant identities of South Africans that are not coming to apply for identity, or the death certificate of the mother, and present that to foreigners which will visit our offices to apply for identity document using those fraudulent documents. And in some instances, South African mothers assisting foreigners to obtain passports for their children. And those are the trends that we are seeing, but they are clearly articulated in the presentation to say what is our current challenge. And on those, we're saying that our business process reviews look deeper into those processes that are vulnerable to ensure that we close the identified loopholes. And the lower levels that are indebted, yes, indeed. In our analysis, we find that our level 6s and 7s at the offices, they are the ones that are vulnerable. They are the ones that are mostly charged because they are easily corrupted and easily infiltrated by the syndicates. But on the lifestyle audit, what we looked at were level 9 and 10. Level 9 and 10 are mostly your office managers and whatever. So, and we have indicated there that we have referred them for vetting. So vetting will dig deeper to see what is the level of indebtedness and what are the causes. Fake documents, yes, we do cancel fake documents. When you look on our investigations, there is a lot of referrals where we would have referred to different business units. We will refer to immigration services. We would refer to civic services to cancel the IDs, and we'll also refer to immigration services to cancel the visas that were obtained fraudulently. Now, when talking about fake documents, let me now couple this with the SIU. I refer to the SIU, what we have already investigated, which was asked by Honorable Rios and Honorable Chabani. Why we did this for us really was to say we were highly challenged on the blocked IDs as a department. Now, cancelling of the visas that were obtained fraudulently, we wanted to test with the SIU to say, when we go the route of cancelling, saying we cancel, are we going to be challenged? What is going to happen? So that was just testing to say, even the TRN project was fully investigated with recommendations, but now referred to SIU, because now there is the route of saying, do we have to write to people that we know that their addresses are fake, their addresses are fraudulent? Do we have now to write to those addresses to say, we are cancelling your ID as per the department procedure, or the SIU can help us with the simpler process of ensuring that we say that you applied for this with fake documents, we cancel. So and we thought maybe they can help us through their tribunal to test the waters in that space. So we have investigated the TRN, we have investigated the study design. The purpose was really to test with the cancellation, because our processes in the department with immigration, and it's rather slow in terms of cancelling, because there are so many things that needs to be done in the process. So on Honorable Matapo, the slide 8, illegal marriages, yes, I would fully agree with you that it's not all marriages. On this one, we zoomed directly into the Moja investigations, where they came to us with documents of the women that were mobilized, that came to say we were married fraudulently. Then we went through the archives of the department. We proved that they were not, they were married, their thumbprints were there were witnesses, the procedure was followed. However, we found our officials to have been complicit, because they knew they worked with the syndicate person. That is why the syndicate person was charged. And I said there that 10 officials were looked into, 5 were already dismissed. So, and really we are sure that it's not all on this presentation. We're really focusing on the Moja Lab investigation. Indeed, on slide 38, the vetting, I've spoken there about the MOU that we are looking at, which is currently with state security legal services. From our side, we have contributed to ensure that there's fast tracking of vetting that we refer to state security. Honorable Ruas, on security officials assisting with queue management, we really discourage this. However, there are offices where office managers would ask security to assist with queue management. However, from the security management, we have discouraged this, to say that's not the role of security to assist with the queue management. And whether we are considering the issue of body cams, remember, the security that is in offices are outsourced. So it means we will have to discuss with the security companies if the issue of body cam should also be considered. So that is a matter that we will look at. And indeed, yes, we have faced budget decrease, which is impacting on the services that we render in the security spaces. And on the issue of half of the cases acquitted, yes, what is happening in this? We're having a report.corruption reporting line. So on this report.corruption reporting line, members of the public would report everything. Some of the cases that would be reported, there would be service delivery issues where maybe a person has applied for ID or something. Then they will report it on our report.corruption line. And other cases will be cases where they would have said, given us an ID number, or they would have given us something, and those cases will definitely refer them to business. And some would be a foreigner who would have acquired the documents fraudulently. The documents would be there. However, when we investigate, we find that these documents are fake. They are not on the DHA systems. So what we will do is we'll refer that case to immigration services to trace that foreigner, ensure that the foreigner is deported, and in some instances we'll refer to civic services if the ID is on the system and what was used was a fake document. And in some instances, it would be really on reasonable grounds that maybe the official would not have seen or would not have known that this document is fraudulent. In a lot of instances that happens, and especially where South African women will be supporting foreign nationals in the process of applying for this document. So the official would really have accepted the documents at face value, thinking that this is the mother. On investigation, we find that actually the South African was complicit, and we ensure that when we refer to the South African police services, they also charge the South African who they found to be complicit. And all the 17 officials identified, yes, we have referred this to SIU. I think I've explained why we have referred to SIU. We have referred these cases also to employee engagement as we referred to SIU, so that the processes run concurrently. We have done that. And on mission investigations, yes, we do refer to South African police services. For us, we charge the official, refer to South African police services. However, the last time, because SSA was also involved, I think the challenge that we had at some stage was the jurisdiction. So if the mission is in Ghana and now we need to charge these officials, at some stage it was a problem of jurisdiction. I think the police are still looking at these cases. We have indeed referred them to the South African Police Services. Honorable Mtolo, comments on security services, the concern. Yes, we are also very concerned about the decreasing number of security officers, and also the cuts. It's really impacting negatively on the department. And yes, we also, Honorable Ngumane, agree that we will ensure that we will work very closely with communication team, which we do in most cases, and also on our awareness campaigns. We also use our comms to help us, because we only have 2 resources in this space. And for us really to achieve targets that we have there is because of the help of communications, which will really speed up, so also ensure that we work very closely with COM or use them more. And also, Honorable Shabani, you also raised the issue of security, which I've said in the presentation there that the DDG Ops, myself and the CFO, we are looking into the matter. But we were told that obviously there is no budget, so it's just a matter of seeing where the money will come from, really, to augment the little that we have. And how does the department engage with missions? We do engage with missions mainly via SSA. Most of our investigation, as I've said, is really integrated. When we having challenges in mission, we'll request SSA to go first to do fact finding, and once there's clarity, then we'll send investigators to go investigate, and they will investigate jointly with state security. So that has been working for us, because in most missions that we were able to get the successes, it was when we approached state security to help, and we find stakeholders really being able to engage and help us. And indeed, documents are cancelled, visas are withdrawn when we find them to have been issued fraudulently. And on the issue of the fake documents, where fake documents are done in internet cafes, for us, really, we request SAPS to help us with that, because we are not everywhere. We are really thin on the ground. We have one official in provinces. So what we do is we really rely on SAPS, and on this one, we are not proactive. We are reactive. We deal on cases that are reported to us. I think I've tried to cover as much as I can. Thank you, Chairperson.
Okay, thank you very much, DDG Moeti. Just before the DG, on the withdrawal of these documents from various students, what will then become the status of those affected students? Or what are the action already been taken? Just clarify that area if you have something to say.
What we have found out is that these are not students. these people are not at those institutions. We have visited those institutions, and those institutions have categorically said to us that these people are not in our institution. Some of the institutions that are given that they are non-existent. There's no institutions like those. And we have also verified with the Department of Education on the list that they have. So those people are not students. They used the student visa to legitimize their stay in the country. However, they are not students. Most of them, that is what we have verified. We have clear proof of visiting the schools where the schools would write to us, respond to us to say, we do not have this particular student in our institution. So, and the syndicates in most cases would use one school. So you'll find that one application would have 100 from a Madras school somewhere. So when we visit that school, they do not have those students. They've not registered. So they've used fake documents and fake everything to say they are at that school. Thanks, Chair.
Okay, noted. Honorable Mokhala, I see your hand.
Oh, yes, Chair. Just wanted Memoitse to, because I didn't hear her respond to the question I posed on the charging officials with treason. I didn't hear her respond on that.
Thank you, Chair. I have responded to say for charging, we refer to we investigate, South African police also investigate fraud and corruption. We refer to NPA. So we'll sit with prosecutors actually to check whether the charges. So what I've said there is that we have not tested charging with treason, and that is what we can look at. And I've said there that we have looked, for now, we have ventured into the Poker Act, where we are having projects where we're looking at charging officials that are assisting syndicate in terms of the Prevention of Organized Crime Act. We have not tested the charging with treason. And I said we will talk to prosecutors and see if it is possible, because they are the ones that are charging. We refer cases to SAPS and NPA. But like I said, we really worked on an integrated approach where we prefer prosecution-driven investigations. So there is that relationship with prosecutors where we will test this. Thank you, Honorable.
Thank you very much, DDG. DG?
No, good morning, Chair. Good morning, Deputy Minister and honorable members. Thanks for the questions that have been raised. I think maybe let me start, Chair, by recalling that in the sixth administration, you will recall that there was a ministerial committee that was tasked to investigate the issuance of visas. And that committee then came before your portfolio committee and then recommended that because of the complex nature of some of the investigations, we should have a multidisciplinary team that is probing some of these irregularities that Advocate Moitse has referred to. The good thing is that the team that has been appointed works quite well with Advocate Moitse and the SIU. And with regards to that question that Honorable Mokhala raised and Honorable Ross raised as to what then happens beyond the investigations. Now, beyond the investigations of the 11 matters that were finalized, these are disciplinary matters that were finalized by the multidisciplinary team. The 11 officials were dismissed. And we also, Honorable Mokhala, claiming for recovery of funds. We've already issued that against an employee's pension. And then there's 2 claims that are awaiting approval, which will also be instituted. And I think the committee should note that this approach by the DHA in the recovery of funds is based by a positive outcome on the Dodo matter, who had taken us to the labor court. And it was then deemed fit that there should be some recovery of funds with regards to that. So we currently are working with the team to prepare claims for the additional officials. Now, there's an issue that's been raised with regards to what then happens at missions. Unfortunately, at the moment, we rely on those missions where we don't have a presence. And the chair raised a question as to how do we then check the activities of fraudulent student visas? The good news, Chair, is that we're about to sign an MOU, Memorandum of Understanding, with Universities South Africa. It's a statutory body, and universities that are recognized are affiliated to Universities South Africa. So which means therefore anyone who claims that they're coming to South Africa to study, we have access to that database so that we're able to check whether this is a legitimate student that is registered with that university. And we meet on a quarterly basis to update them through Mr. Simons, who's acting DDG Immigration. And once we have finalized that agreement, we'll then ramp up so that we do not have people that come through and they are not really registered. I think Advocate Moise did indicate that out of that investigation by the team, there's about 24,608 student visas that were of the view that in our discussions with the SIU, this should then be set aside. If they are set aside, therefore means, Chairperson, that those people will then be declared to be regular in the country and therefore should be deported out of the Republic of South Africa. That's with regards to that. And then there was another question that was raised with regards to the unfunded positions. I think it was from Honorable Matopa. If you recall, Chair, in one of the presentations by HR, we had indicated that the approved staff establishment for the department, it sits at around 18,000, but we only have about 7,200 funded vacancies. So if it's not funded, it means we can't fill that position because we won't be able to pay that person a salary. And I suppose we've made a presentation, we've made a business case to Treasury to consider funding us for those positions. And I think Advocate did indicate that with the initial 12 positions that counter-corruption has received, they are really going high-tech, looking at using data analytics in their fight against corruption, which I think it's working quite well for them. And then let me also deal with the question that was raised by, I think it was Honorable Ngubane. I think it's more a recommendation that we need to communicate more in terms of the work that's done by this unit. We agree, we need to communicate more. There's a lot of work that's underway. I think on the lifestyle audits, the DDG, Moise has already responded to that. That has already started. Similarly, I think Honorable Mokhale raised the issue around how we deal with perception. It's more around communication. And then I think I've responded on the issue of staffing and the budget, Honorable Mokhale, that we have made a business case to Treasury and we'll wait for the budget, whether we'll get anything. If not, we'll obviously have to look at how do we reprioritize some areas. But the CFO is also online, Chair. I'd wanted him to respond to the issues around the budget pressures. And I suppose we are not alone in the cluster. The entire JCPS cluster is really feeling this challenge, which is why a lot of the activities that will enable us to digitize will assist us with some of these issues. Just the last issue that I thought I must raise, Chair, with regards to fraudulent marriages. Mr. Skama shared with me some stats that between 2023 to 2025, we have had about 1,364 fraudulent marriages that were reported. Now, where people would have gone and signed, as you were saying, Honorable Makli, where people would have said, well, I'm taking part in this marriage because there's a monetary value, which is referred to as marriages of convenience. And they can't get out of that. We're trying to work with the Department of Justice to look at how we can really assist them to expunge those marriages. Out of that 1,364, there's about 453 that's been expunged. And then we've referred about 71 of those cases to court. And then we've got 840 that remains, that's still under investigation. And the causes of these marriages of convenience they vary. Sometimes it's for a monetary value. Sometimes it's where employment agencies ask people to submit their IDs. And in the end, they then accidentally are married to other people. And then, of course, you also have criminal syndicates that operate in this area. We do have a procedure in terms of how members of the public can report fraudulent marriages. I suppose we can share with Eddie the number where people can complain with regards to that. Our task is to assist anyone who believes that that marriage, if they did not enter into it voluntarily and being of sound mind, to really assist them to get out of that. And where it's difficult, we then bring in the Department of Justice because the matter is to be enrolled in court. So, Chair, if I can ask CFO maybe just to speak on the funding. Thank you.
Thank you, CFO. CFO. Okay, DM.
No, thank you very much, Chair. I think we are all on par on the issue of congratulating the team on the good work that they've been doing over the past years. I think when we took the decision, building from the 6th administration to have the counter-corruption unit, we can all see now that it is really bearing fruit. But obviously, Chair, we are not there yet. There is still a lot more that needs to be done by the unit so that we have a corruption and secure environment within the Department of Home Affairs. I think the issues that we are taking from this meeting that we need to then deal with, one around the issue of properly resourcing the department. And our plans is that we resource it by investing more on technology and digital infrastructure, which will really help us deal with the issues much more effectively. I think the move to build towards a digital ID will also help us further amongst all the aspects that the team has to deal with. For instance, you are able to trace the movement of currency and payments much easier within the digital platforms. It will also allow you to have early detection sign of risky employees in the future. So those are very important. I must also indicate, Chair, that obviously with the work that we are doing and getting rid of all the people who are not doing well within the department, and in fact, giving a bad name to the department will also attract negative connotations, which we then have to mitigate as the department. Because remember, as we extract people out, media then takes that posture that there is a lot of people who are going out. It means the environment is corrupt, whereas we are literally sanitizing the environment. And for me, I think we need to look at the positive, that the number of people who are getting out is as a result of, meaning the environment now is safer, the environment is secure, and that the environment is being sanitized, and that indeed we are staying true to our commitment of creating a non-corruption tolerant department, and we are living true to those values. I think there is a lot that we still need to do also in the front of the issues of fraudulent marriages. They are coming up quite strongly, and I think beyond just enforcing the law, we also need to meet them halfway in terms of making sure we run media campaigns that are meant for purposes of alerting citizens on what are the repercussions of these marriages of convenience. And I think once we do partner, because most of the threats that we receive are not only by officials or syndicate also, but they need some level of participation from society. For instance, if you're talking about the photo swaps, it will not happen if you don't have people who are willing to sell their citizenship. So I think we need to tap into that as well. But I think good work is being done. There is more that we still need to do. And it's clear that we are truly holding true to our principle of creating a corrupt-free Home Affairs. Thank you, Chair.
No, thanks very much, DM and the DG and the DG Moeti for the comprehensive report, but also for members of the committee to have identified progress and also identifying some of the issues, recommending some of the issues that the department may need to look at. But also I think it's all our collective responsibility to, as members of parliament in our various spaces, and also the team of Home Affairs to continuously educate society in relation to the subject matter, particularly on this fraudulent ID scam that is continuing to cause harm to our residents. So I think it's an important front that we must take responsibility to continuously create an environment of awareness around this corrupt activity. Thanks very much. We'll step off the item. I will request colleagues that we deal with the two items at once, the brief by DDG Sigama on this court judgment and also on the report that we're expecting. Then we'll comment on all the issues that are being raised. I'm not sure how it's going to be introduced, the two items, DM, and I'm sure DM, you are not doubting that Honorable Ngubane has a wrong ID. I've noticed that you were quiet on his birthday. I'm also doubting whether it's an accurate day.
It's highly accurate, Chair.
Thanks, DM.
Indeed, Chair, it is the birthday. I was still gonna call Honorable Ngubane on the side and wish him a happy birthday. But since you put me on the spot, Chair, let me wish him all the best and wish that God blesses him abundantly and akhule kodwa angakhokhobi, Chair. We have with us Advocate Malakate, who is here with us, who will be taking us through the presentation on the court judgment, which was mainly dealing with the issue of dual citizenship to those citizens who had lost their citizenship before, and they had to apply to the minister, and by implication, as a result of the Concord judgment, they no longer need to do that. Because in South Africa, dual citizenship is allowed. It has to do with Section 61A of the Citizenship Act. There are steps that we have taken in order for us to start the process of the implementation of the judgment. For instance, we have circulated an internal memo to our branches on how to handle the issue. And also we have issued a media statement on the matter, and also a DG to DG letter has been prepared and sent to DECO so that we can communicate with those who are staying overseas. And we are now finalizing the development of the portal for electronic applications. But I think Mr. Advocate Malakate can take us through the presentation. It's not a very long presentation. And then ultimately, Mr. Sigama can then just make references. Possibly DG can lead that part where we make references of the process that we have taken, but it's all in one presentation, Chair. Thank you.
Okay, thank you very much. Then also deal with the two items of Toyana and the other updates. Is that correct, Ian?
Yes, Chair, we can deal with that, and just maybe as means to mention that in some of the issues, you will know, Chair, that there are issues of the protection of personal information laws that we have in the country, and we have to abide by them. We have written a letter to you, Chair. It has been signed on the responses that we have dealt with. But just as a matter of a quick highlight, is that some of the person in mention is in possession of a PR, but we do not have any records of naturalization, and I will suggest probably that one we deal it from there. On the issue of the Mulelwa Toyana matter, we just realized that we only came to contact with her in 2022, which was really about a change from Avasong to Toyana. And there was a notice now of a fraudulent marriage that was dealt with us in April 2025. But upon our own investigations, there are some aspects that we really need to confirm and deal with. I can say, Chair, that we are worried that this might just be another matter of a marriage of convenience, because in terms of our records, we've been able to find the records of the marriage and how it was actually registered. On the issue of the on-print, we are looking for the client. We've really been struggling to get hold of the client affected, but the team will then take us through. Probably let's have the Advocate Malakane take us through the presentation of the Concord, and then the DG will take us into more detail on these cases. Thank you.
Thank you, DM. Advocate Malakane.
Good afternoon. Good morning, Chair, honorable members of the Portfolio Committee, Deputy Minister, Director General and Deputy Director Generals and other officials of the department on the platform. Chair, let me just first also wish Honorable Ngubane a happy and pleasant birthday for the day. So, Chair, I'm not going to spend too much time, just to remind and recall that as it relates the litigation history on the matter, we just wanted to indicate and remind the Portfolio Committee that this matter started at the High Court. It went through, appealed, and it was heard by the Supreme Court of Appeal. And the Supreme Court of Appeal, Chair, had then made a certain pronouncement in relation to Section 61A of the South African Citizenship Act. And in that order, they have then ordered that the Section 61A was inconsistent with the Constitution from the date of its promulgation way back on the 6th of October 1995. And essentially this then, in terms of the law, every constitutional order or every order that impacts on the constitutionality of a legislation would need to be confirmed by the Constitutional Court. Hence, this matter was then before the Constitutional Court for the Constitutional Court to confirm the order of the Supreme Court of Appeal as it relates to Section 61A. So indeed, on the 6th of May this year, the Constitutional Court then confirmed the invalidity order made by the Supreme Court of Appeal, and also reiterated that the Section 61 was in conflict with the Constitution, and it's invalid from the time it was promulgated, and that period being 6 October 1995. It further ordered that all those who have lost their citizenship by operation of this section are now deemed not to have lost their citizenship from the date referred to in paragraph 2. So properly understood, Chair, in the next slide, it then means that in terms of this judgment, and just to recap, and then we will also deal with this aspect. So in terms of Section 6, Section 6.1 deals with the circumstances under which a person may lose his or her citizenship. And then Section 262 then provides a mechanism wherein the person who may have lost his or her citizenship can also apply to the minister, for the minister to then issue or a recommendation or make a decision that such a person would retain his or her citizenship. So the Constitutional Court then said, no, that should not be there. So what it then means is that the judgment does not require, there was no order that required the department or parliament to repeal or amend the provisions of the Citizenship Act. What it then means is that the Section 61A of the Citizenship Act has been deleted from the legislation. That's number one. But the implication also, it means that the department must now go back to the 6th of October and try and find out who may have lost his or her citizenship on the basis of implementing Section 61, and ensure that those who may have lost their citizenship is now restored. And this will ensure that the department fully complies with the judgment. In the next slide, Chair, we're just recapping what Section 61 it's all about. It required that in the event that somebody, by any not being a minor, and by some voluntary act and formal act other than a marriage, and he or she acquires citizenship or nationality of another country without applying for an intention in terms of 62, that person would have lost their citizenship. So now we know that this provision, Section 61A, has now been deleted. So what we currently are going to have is Section 61B and 62 in this provision. In the next slide, we just reiterating again what the Constitutional Court has been indicating, primarily that there was no value in their analysis of the chronology of that provision, that the minister actually it does not really have that power to restore nationality under the circumstances, because a failure to do so leads to an automatic cessation of South African citizenship by virtue of Section 61A. So that power that is there in Section 2 doesn't, even though it is there, it's not really used. And the court has also indicated that there are no clear guidelines as to what the minister would need to follow in order to give effect to the power that is granted in terms of Section 2. In the next slide, again, is just a reiteration of what the court has in coming to the conclusion that Section 61A is inconsistent with the Constitution. What was their reasoning? And again, they just reiterated, the Constitutional Court reiterated the provision of Section 20 of the Constitution, in that it guarantees citizenship to all those who are eligible and who are South Africans by birth, and that deprivation of such citizenship has impact on rights that are contained in Section 19 and 21 and 22. In the next slide, again, is just a reiteration of what the Concord then came to. Primarily, that the important issue, Chair and members of the committee, is that from the date of the order, we need to go back to the 6th of October 1995 and ensure that all those who may have lost their citizenship on the basis of the implementation of 61A, their citizenship gets restored. There may be other circumstances and consequences that we would need to take into consideration. For instance, Chair, there may be an instance, and I'm just thinking out loud, and this is not the position of the department. There may be an instance wherein perhaps as we are restoring, a person raises their hand and say, I actually do not want to retain my South African citizenship. I want to continue with the citizenship that I have acquired. And those may be the circumstances that where perhaps they may be a slight change in the operationalization of that. But of course, Chair, as I'm indicating, this is not the position of the department. It's just Moses thinking out loudly on circumstances that we need to take into consideration as we fully comply with the legislation. So in the next slide, Chair, again, we were just reiterating this issue. But just importantly, that there is no suspension order in this matter, so generally the impugned provision has been struck down, and therefore the court then said a suspension order is therefore unnecessary. So what we currently have from a legislative development processing, we don't need to do so or come up with the legislation to simply delete that provision. It will be deleted by this court order. The steps that have been undertaken, Chair, and members of the committee, from the date and prior to the judgment of 6 May, was that the department has been anticipating that there may be a negative outcome from this court, and we set in motion and prepared for it. And one of the preparation is that we needed to come up with a draft circular to be circulated internally, in terms of which we are communicating the impact and the court judgment and what it means and how offices should then deal with these issues. In the next slide, we are again indicating that from the department side, because these matters will also affect our missions abroad, there needed to be a DG to DG letter from the Director General for Home Affairs and a letter addressed to the Director General for the Department of International Relations and Cooperation, so that the DERCO, in terms of the Foreign Service Act, is responsible for all foreign missions, and therefore they would need to communicate the judgment and the impact of the judgment and what the missions would need to do in order to ensure that there is a full compliance with the court order. There was also a draft media. There was also a media statement that was drafted in order to communicate this judgment, and this was also issued on the 6th of May immediately. There is also a development of a portal in order to accept the electronic application for those who have lost their citizenship in line with the impugned provision. And this is currently sitting with our information technology branch, and they from the civic service side, they made the change request, and it is now for the IIS to develop the portal so that we can do so, and we are anticipating that this should be up and running before the end of this of the month. Okay, with that said, we wish to submit to the portfolio committee for the portfolio committee to take note of the contents of this presentation, but also to take note of the steps that the department has undertaken and is still going to undertake in order to fully comply with the judgment. I thank you, Chair, and members of the committee.
Thank you, Advocate Malekate. DJ?
No, thanks, Chair. I'm covered. Nothing to add. Thank you.
DG, is the 2 updates covered by the DM so that we invite members to comment on the 2 issues? Yeah, Toyana and Phil Craig.
Or you want me to take you through that one, Chair?
Yeah, I thought let's deal with the two items, then members will comment, and then we were able to manage time.
Oh, okay. No, thanks, Chair. I think by now you would have received, Chair, a letter from the Acting Minister of Home Affairs on the three matters. On the first one, which is the Phil Craig matter, the minister indicated that in his previous response, he had indicated that Mr. Craig is a permanent resident, and that was granted in 2009. And the indication in the letter further is that in terms of our own records, we've checked with our offices. We have no application that has been lodged for his naturalization with regards to Section 5 of the South African Citizenship Act. That's with regards to Mr. Phil Craig. On the second one, Chair, this is in relation to these marriages of convenience. On the Bulelwa Toyana matter, the department first came into possession of the complaint in 2022. We couldn't find any complaint that was lodged in 2015 by Bulelwa. Now, the complainant wanted to resume the maiden name. The surname was reverted from Avasong to Toyane, which is the maiden name, on the 16th of August, 2022. Now, Chair, after the alleged fraudulent marriage was brought to our attention and your attention on the 16th of April, 2025, these are the steps that we took. We were in contact with her on the 16th and requested her to submit an affidavit and also to report the alleged marriage, fraudulent marriage at the Mthatha office. She subsequently lodged that application on the 17th of April, and therefore we then started with an investigation that we initiated through our team at Immigration Services and Head Office respectively. And the findings were as follows. One is that the original marriage, as Honorable Makwe was saying, was first registered in 2008. This is a marriage between Mr. Wilson Augustine Avasongo and Ms. Bulelwa Toyana, which was solemnized on the 3rd of May 2008 at the Christian Community Church in East London. Our records also reveal that Pastor Vali John Hoyana, and he has got a Home Affairs designated number BD 236203, was the pastor that presided over that. Unfortunately, he has since passed away on the 22nd of July, 2014. Now, given what I've just said, Chair, the marriage that was conducted between Mr. Wilson and Bulelwa Toyana remains valid. Now, unless if she approaches the court to have that dissolved, it's quite difficult for us to expunge it at the moment. And in our advice to her, we've indicated that she needs to approach the court. We'll see what assistance we can provide with the DG of Justice so that that marriage is then, so that there's a dissolution of that marriage. And of course, once the court has issued a divorce decree, the department will then expedite the expungement of the record of marriage. So that's with regards to the second matter. The third one was Stephen Dion Prince, wherein it was alleged that Mr. Stephen Dion Prince divorced his previous wife in Israel, and that his marital status has not been updated on the National Population Register, or the NPR. which therefore makes him unable to register his subsequent marriage with the alleged current wife from the Philippines. Now, Chair, in cases where a divorce is finalized in a foreign country, it's important to note that the client must first visit a local office and submit a translated apostilled foreign divorce decree. And of course, a copy of the South African ID. Subsequent to that, our offices will then do the online verification of the client, and then the marital status will immediately be updated to assist the client. In this specific matter, Chair, we've been trying to make contact with the client, but it's been impossible on the numbers that we have. The Beca office has contacted, has been trying to reach out on the numbers that we have. And so far, we have not been able to reach out to the client, because once we have received the details, it would have enabled us as the department to establish some of the correct information on record. Now, we then requested our inspectorate unit in Beca to check further this matter, and they came back and indicated that the wife from the Philippines has since left the country on the 9th of April 2025. Now, this has been confirmed through our movement control system. So for us, Chair, to be able to resolve this matter, any member of the portfolio committee, if they can share details or contact details, it will assist us to resolve this matter. Thank you, Chair. That's all with regards to the three queries, but I think the letter by the acting minister would have been dispatched to yourself. Thank you.
Thank you very much, DG and Advocate Malekat. I'm now going to invite members to comment on the two updated reports. I will start with Honorable Mohale, Honorable Ross, Honorable Machi. In that order.
Thank you very much, Chair. Just on a lighter note, Chair, I realize that we have proceeded with the meeting and I've not heard any single person congratulating Kaizer Chiefs. But that's fine.
Oh, after so long, they've been defeated.
No, it's fine.
Let's proceed. We're protected. Thank you for the reminder.
Thank you very much, Chair. Chairperson, I want to firstly start with the issue of Mr. Craig. Well, while I might maybe accept the response by the DM, but I want to refer to Section 30 of our Immigration Act. Section 30 of our Immigration Act, which deals with people who are declared undesirable persons. There's a provision there which makes it clear that anyone who presents a threat to our national security will be declared an undesirable person. This guy who is leading this cessation movement in South Africa, we know he's a British citizen, and the minister has indicated that he is here on a PR and he has not applied for citizenship or anything. My question is, when are they going to withdraw his PR status and deport him out of South Africa on the basis of Section 30 of the Immigration Act, which is very clear, Chairperson,
that anyone who threatens our national security, Chair, must be declared an undesirable person and removed from our country. So I would like to hear a response from the minister. We have learned this morning that they have declared the rapist, Tim Omotoso, as a prohibited person who must be deported from South Africa. And if that is the case, Chair, it's a welcome development. We welcome that action that have been taken by the department. However, we want to see action being taken against Phil Craig. And for that, Chair, we make no apologies. Action must be taken. We must send a strong message to this kind of people, Chair. Otherwise, we are going to become a playground. This country of ours is going to become a playground where anyone is going to come from anywhere in the world and do what this Mr. Phil Craig is doing. And we're just going to fold our arms and do nothing. So we want action to be taken against Phil Craig, and we want to know when will that action be taken on the basis of Section 30 of the Immigration Act. That's number one, Chair. I want to then deal with the issue of the Constitutional Court outcome on the issue of citizenship. Firstly, I welcome the presentation from the advocate that at this juncture, we don't know the number of people who are affected and thus liable to reapply for their South African citizenship. And I think that would be very important, Chair, because remember this thing was brought, it's political, Chairperson. We know this matter was raised by the DA, and it's for a specific reason, in my view, that they are trying to bolster their numbers internationally from these people who left South Africa so that they get more votes overseas. Because we want to understand, Chair, does this mean restoring of citizenship of these people will also include, if they are married, their spouses and their children or adopted children in the countries where they've taken citizenship? Is that the implication of this court judgment? Is that the implication? And also, Chair, I think the process of the white paper, as we said last time, really, it's very important in this regard because, you know, we really need to deal with this issue of citizenship and what it means. This thing of dual citizenship, Chairperson, it was never there before 1994. We know the South African Citizenship Act of 1949 was very clear on this thing. It was only when we were approaching the democratic dispensation that this thing of citizenship, of dual citizenship, was now raised and started becoming an issue. Because the question, Chairperson, we should raise is, does this mean that it's possible for South Africa to have a president who is a dual citizen of another state? Because at the current juncture, Chair, there's nothing in our statutes, in our laws, that outlaws that kind of event from taking place, where we have a president who has a dual citizenship of another country. We don't have a provision in our laws that outlaws that kind of a thing. And also, Chair, remember, this thing of citizenship also has implications for our state security, and it can compromise the security of our government. And I just want to also understand also with regards to taxation, do these people, Chair, are they tax-paying South African citizens? Because if their citizenship is going to be restored, it will mean that we are going to spend millions during elections to get ballot papers to them so that they are able to vote if they decide to register to vote. So the issues of tax as well, Chair, it's nothing, it's something that we must not ignore, because it is unfair, Chairperson, for people to benefit where they are not sowing. They are not contributing anything to the fiscus, but they are benefiting on the basis that they are South African citizens. So my view, Chairperson, is that, you know, the white paper, these are some of the issues that should really be dealt with in that white paper, as allow the citizens of this country to engage on what it means to be a citizen of South Africa exactly. Do we want this thing of dual citizenship? And what are its benefits to us as South Africans? Thank you very much, Chair.
Thank you very much, Honorable Mufale. Honorable Ross.
Thank you, Chair. Chair, of course, the DA welcomes the Concord ruling. And, you know, we think it's very important, you know, this deprivation of citizenship. That is what the court rules, that South Africans shouldn't be deprived of their citizenship. And also we should celebrate the striking down of an apartheid era law, which was utilized to strip the citizenship of South Africans that went into exile and then happened to take on a second citizenship. So I think it's something that belongs as a relic of the past, and we're pleased to see the back of it. I also welcome the indication that the portal might be ready towards the end of the month. Of course, we as MPs are already receiving a lot of inquiries due to the nature of the fact that the judgment said that you have your citizenship back immediately, but of course that needs to be changed on the National Population Register. I just have 4 small questions in that regard. Can the department indicate what will be the process for those that don't want citizenship? Will they then just not reapply, or will they have to state that they don't want it back? Then the second question is, will citizens get their original ID numbers back? Because you can imagine, having lost their citizenship, now they might have applied for permanent residence, for example. They might have got another ID number. Will their original ID number, as it was when they lost their citizenship, be restored? Then the other question is, what would be the process for South Africans then returning to South Africa to apply for their documents, given that it still takes quite a long time for persons to get an appointment at an embassy abroad to apply for an ID or a passport, that many might choose to come to South Africa to apply. So would they be able to return to South Africa on their foreign passport to be able to then apply for these documents? And then finally, what would be the case where someone had lost their citizenship and then been on a foreign passport and for some reason overstayed, and then currently been banned on the travel system? Will those bans then be overturned? Those are all the questions from me, Chair. Thank you.
Thanks very much, Honorable Ross. Honorable Machi.
Thank you very much, Chairperson. To me, Miss Bulelwa Toyana, she didn't meet her expectations. So she wants to be out of the marriage. Then she needs Home Affairs to intervene. She knew this marriage because this was also even celebrated because they know the place. And it's unfortunate, Chairperson, that these marriages which are said to be fraudulent. They are involving our women, South African women, not the men. And it seems as if the women are desperate. These South African women are desperate. Because to this one, there is also even a venue where this marriage was performed, which is Christian Community Church in East London by pastor. So she can't be free from this as if she has done nothing. I would like to find out how the department going to deal with Bulema, because the world should know that these fraudulent marriages, some of them are known, not just because they are the Home Affairs officials are only ones which are conducted them. Yes, there are some officials, but most of them, these South African women, they know them. So now the other question is it possible to dissolve this marriage without the knowledge of the man? I don't know, maybe it's Avasango, because I can't I can't pronounce this surname. But is it possible that the marriage can be dissolved without the knowledge of Avango? Because I can hear when the presenters are saying the only thing that maybe Bulelwa can do is to go to court so then the marriage can be dissolved. So I would like to find out that is it possible then would the marriage be dissolved without the knowledge of Asavango? Thank you very much.
Thank you very much, Honorable Machi. Honorable Ngubane.
Yeah, thank you very much, Chair, as well. Thank you as well, colleagues, for the birthday wishes, and thanks, DM, as well. And then back to this matter of the lady, Bulelo. Chair, in South Africa, we're living in the dire situation. The economy is bad, the crime is rife, everything is honky-dory. So what Home Affairs needs to do with Ms. Bulelo, you need to find a way of resolve. People who take advantage of our people's poverty situation needs to pay the price, as well as people as well who want to use this opportunity of Home Affairs to get money from foreigners who, because it's a two-way street. There is a lady that wants to make money on the foreigner, and there's a foreigner that wants to make money on the vulnerable women of our country because of poverty, economic downturn, and everything. Home Affairs needs to have a tight system to deal with both these people. Penalty, revocation of whatever the foreign person was paying for to get whatever citizenship, so that they can see that their money was not utilized fraudulently for wrong things. That needs to be in place by Home Affairs. If someone was married for wrong reasons, they need to lose their money, revoke whatever they've benefited fraudulently, and see that their payment was fruitless and they were conned. In that nutshell, the lady as well needs to pay a price for desperately abusing a foreigner to source money. There needs to be a two-way penalty so that these people don't get involved. Because at the end of the day, we might criticize Bulelo, we might criticize the chap as well who did this. Both of these people were on the wrong. There needs to be a harsh penalty for both of it so that no one gets involved in these criminal activities that makes our country looks like a banana republic. It needs to be in place, Chair, on the Bulelo. And then, Chair, on this guy from the guy from the things with Mr. Phil Craig, the minister needs to act on this. And I see, Chair, on the letter, the minister seems to be much softer on the Phil Craig, that they found out that he's got a permanent residence in South Africa. This guy has done horrendous things. He's calling for independence, but he stays in South Africa. He's calling for all sorts of shenanigans. Action needs to be taken against him. Even the freedom of speech or whatever freedom, it doesn't mean that he must start to cause chaos in the country. If you want to go and live in the UK, he must go and live in the UK and leave us in peace. And he can't come here to South Africa and tell us that some provinces need to have independence or whatever shenanigans he's dealing with. So laws needs to deal with these people and some of the wrong things that need to be done. If he's got the permanent residence and a permanent residence in the UK on both, now because the law that has been enacted by the Concord around May allows him to do so. But there needs to be punitive measures on the wrong things that is promoting and where he's trying to push in on the agendas that are against the management and the running of this country, Chair. These are two issues I want to talk to. And then the third one, Chair, is this issue on the court judgment on the citizenship. Chair, this is a huge transgression of justice. If you remember correctly, Minister Motsoaledi opposed these things last year, and I think that the year on the sixth administration, he opposed it vehemently. And I think even the previous Home Affairs ministers, they went on the court and paid lawyers to oppose these things vehemently. So now, Chair, because of the GNU and there's a new minister, and then who's conflicted on the matter, on the other side is a minister, and on the other side, it's the party he represents that is taking this matter into court. And there, the person that is party to this is a DG and the Home Affairs Minister. All of a sudden, because now the minister is of a certain party, there's no representative from the Home Affairs to argue against this case because it's wrong. It's people need to have loyalty, their loyalty known. People need to, you can't have, Chair, a person who's enjoying comfort in London or in New York, sitting nicely and is not affected by load shedding, potholes, all crime in the country, and everything that the citizens of this country, people who have one citizenship, are at the receiving hand. A person is sitting somewhere in London on comfortably nice flat, and they're in London, but he wants to participate on the voting, on the directing of the political direction of the country in South Africa. And that person wants to contribute on who must be the government and how we must govern this country. But that person is not affected by the political directions and the results that we receive in the country. That alone doesn't sound okay. Just choose your loyalty, right? At least if we can try, Chair, and even on our constitution, remove some of the benefit from these people who want to have both world to themselves. I don't know how greedy they want to be. They want to have both world on for themselves. And then after that, they want to go and revoke the constitution that because I'm a citizen of South Africa, I deserve all the right of being a South African. But you're sitting there in London or in New York or in Italy comfortably and not suffering what we are going through with whatever political direction we are going through in this country. And the other critical things that Honorable Mohale has counted, how would we handle now that person when he wants to campaign as a president now? How would we handle that situation? And can the constitution allow him to have all the constitutional right as a citizen of this country? Now, this person is staying in London. He wants to campaign to being the president of this country or to being an independent. How will that be handled? How did the judges look at that as well? So these are all the ills, Chair, that we see. As I highlighted in our previous meeting, there is a loophole in our constitution and people are abusing it for nefarious means. A lot of people, Chair, are complaining about this because the first person who was excited about these things and went on social media was the minister himself. Even championing, says the e-Home Affairs, the digitization. We haven't implemented the digitization of Home Affairs, but he associates this court ruling that happened before 1994, this case. But now, because he wants to pretend as if the digitization is now working, look at how we are going, the e-Home Affairs, people from overseas can go online and apply for whatever they want to apply. It's on him because he's conflicted. He's a member of the party that has taken Home Affairs into the government, and he's the minister on the other side. The court doesn't see even all that as a conflict of interest on both what is happening in our country, and we are seeing it. There is a wrongness in patriotism here, and there is a wrongness, Chair, in allegiance, and in this ruling. There is whole lot of things that doesn't add up to say how can these things be allowed, Chair. I know constitutionally, as I said, there is a loophole in this, but people who are being disadvantaged much are people at the lowest level, people who don't have the luxury of having two citizenships. There are people, Chair, when this country bans, they don't have anywhere to go. They will ban with this country. And these people who have a luxury of somewhere else to go when this country bans, they are sitting there, they want to vote as well. It's so totally unfair to people who have one loyalty and one allegiance in this country. Even Honorable Mohale mentioned the tax implication, tax contributions. There is a whole lot of variables that doesn't add up. Somewhere, somehow, I'm worried that the minister is conflicted, hence he didn't participate in this court in stopping it because he's conflicted in this thing, Chair. It's so unfair. As MK Party, we reject this court ruling with the vehement it deserves, and we need to look at it, Chair, on how we can reverse this court judgment. This saying of saying these things was unfair to the people who were politically participating in 1994. 1994, before 1994, we were not voting, Chair. We were not even allowed to vote. So it didn't touch the part of voting, which is the part that we're complaining about. What I will ask, Chair, in conclusion on this matter, we're going to ask the department, because the minister, even on social media, branded a number of these people that they're going to benefit with this court ruling. The number was around about 1.4 million or 2 million. What we'll ask, Chair, in this committee from Home Affairs, we're asking the officials to give us a breakdown, because it's a mammoth task they have to do to restore the citizenship of these South African expats, some of them. We will ask the breakdown from the Home Affairs of these foreign people by country, by region, by race, by gender, all the statistics related to this 1.4 or 2 million people, so that we see that who's really benefiting on this, because it's clear. The people who are benefiting out of this concord, the people who are popping the champagne, is the DA. All of us South African, I can tell you 90% of South Africans are not happy with this concord ruling. But the people who are ruling is the minister who are enjoying this concord ruling, is the minister himself, is the DA. So what we'll request from the Home Affairs, if they can urgently give us the breakdown of these statistics of these people that they will do, so that we can see what is going on, how can we manage this situation? Because it's so totally unfair to the poor South African of this country. As MK, we reject this court ruling. We need to find a way to reverse it. People need to be having one allegiance, participate where their bread is buttered, and be able to say, I can't vote in South Africa because I'm not staying there, I'm staying in New York. I will only vote in New York at this time around and not in South Africa. And don't vote where they are not staying. That's my conclusion, Chair. Thank you.
Thank you very much, honorable members, for your contributions on these two important issues, and thanks, Advocate, for having taken us into the brief and the DG on the two issues. I'll request you to comment. The reason, and I think all of us, we are now firm that some of these issues will find expression when we deal with the white paper, and we allow conversation, South Africans, to interact as we review this regime on the citizenship and And this will be an important conversation that we'll need as a country. And the reason that we're being firm on that area, it was also the anticipation of this question that we're sitting with today. And I think obviously in all the legislation has been amendment that have been carried, but also constitutional court or judgment by the courts for Parliament and the department to mitigate with the process of amendment. So I'm raising this that the agency on the white paper is more important than what the department has targeted in 2030. And I hope that when they come back, they will have considered many factors that the committee has raised. On this matter of Phil Craig, before you respond, DM and the DG and Advocate Malekat, we will sort a legal process from how we respond to a letter and the content that are detailed there. Will engage with the Parliamentary Legal Services to reflect on what is to be responded in the course of action that you may need to take. You're fully aware that also the President's spokesperson also highlighted around the status of Phil Craig. And also on this judgment, we'll also further sort legal clarity and details without saying that we were not welcoming this report. We're welcoming a report, but in terms of the process moving forward, including if these other issues can be captured in the white paper when we deal with that. Can I invite the Advocate Malekat?
Chair?
I see the hand of Honorable Mokhale.
Yeah, Chair, just before you invite Advocate and DG for responses, I just wanted to add one more issue, just maybe if they will provide clarification as well once they respond to everything. Chair was sitting with the issue of so-called Afrikaner refugees who have taken up the offer made by Donald Trump on the basis of fake white genocide that is alleged to be taking place in South Africa. The Minister of Foreign Affairs and the President have expressed themselves yesterday on this matter. Now, for us as the committee chairperson, I want to understand, Chair, whether do such people really deserve to retain their South African citizenship, Chair? When they have said that they are not safe here, they don't feel that they have any prospects at all, they are being oppressed, which are all lies. And they have been accepted in the US and they are in the process of obtaining US citizenship. Should we really keep such people on our citizenship, on our national population register as citizens of this country? So as Dade Malekate response, it's one issue that I just raising that maybe we'll also respond to, because in our view, Chair, we want these people and we are going to advocate for it very strongly, that these people must forfeit their South African citizenship. Thank you, Chair.
Thank you, Advocate Malekate.
No, Chair, I think most of the questions relating to the judgment, I think we take note of that, and also appreciate the support that we got from some of the members of the committee in relation to the work that we had undertaken in preparation the judgment and what we intend to do going forward. Chair, there are other matters that I think they would not fall within my competence, but should maybe perhaps the DG or would be able to respond to. But in the main, I think most of the issues that are being raised are matters that are beyond the judgment itself, matters that we perhaps would need to deal with under the white paper that we are currently dealing with, so that we can have maybe perhaps a public discourse on the matters that have been raised. Thank you, Chair.
Thank you, DG.
No, thanks, Chair, and thanks, honorable members, for the questions. I think, Honorable Maki, on the Bulelwa matter, we will try working with the Department of Justice to see how we can really assist Bulelwa with regards to how that marriage can be expunged. And I think to that extent, DDG Skama has written a letter to her to provide her with directions in terms of how we can provide support. And of course, as a department, we have to be to have that compassion to assist people that are like Bulelwa in this difficult situation. And then Honorable Ngubane, again, happy birthday. I suppose amongst others, in seeking how we can assist Bulelwa will be to engage probably even legal aid board to see how they can support her. I will recall that a year ago, there was a South African who was stuck in Nigeria, married to a Nigerian with children, and they were in a very desperate situation, and working with the mission, we were able to assist. So I suppose the same will have to apply in the case with regards to Bulelwa. I think we've noted the request around the breakdown of these foreign nationals, the 1.4 million by country and by gender. I think Honorable Mukhale, I think I've taken note of what you have indicated. And then Honorable Ross, the process in terms of carrying out these issue relating to citizenship. Our plan is to ensure that we have a portal that is functional, that will enable those that want to reclaim their citizenship to do it online instead of filling forms in line with our digital transformation. Already, we have drafted a circular which will be shared with our offices to look at how we'll deal with this process. I think DM will then deal with the other issues with regards to Mr. Phil Craig. And I think on the white paper, Chair, we've taken note of that, and that's what we will do. Thank you.
Thank you, DG. DM.
No, thank you, Chair. I think overall we do take note of the issues that have been raised by members. And obviously, some of the issues, I think they will need us to create a platform for broader engagements and more deeper engagements on them. The only few issues probably would comment on is firstly that it's very clear according to the Citizenship Act on what rights a person has when they become a citizen. And I think all those who will have been declared citizens will then be entitled to those rights. It also involves the issue of how a person becomes a South African, and which is obviously by being born of South African parents or from people who already have citizenship. I think that will give some highlight on then how, on the magnitude of the administrative processes we have to engage on. I think on the Philip Craig matter, Chair, we will need to get a formal complaint for us to start handling the matter. I think we have raise that particular issue, that when we do our work, we do not do it on the basis of just the media discourse or what is on the media. We have to deal with the substantive matters and the substantive complaints that are then brought formally. Then we handle the matters and investigate and ultimately get to the conclusion. I think when we dealt with the Chitima matter, we highlighted that in higher detail, that we must follow the law to the utter in order for us to deal with issues. On the issue of the marriages of convenience, we are mainly responsible, Chair, for the issue of marriages, but not divorce. And the issue of divorce then falls within the Department of Justice. And that is why we keep on saying the problem with the marriages of convenience is that when we have investigated and we established that indeed the marriage was legitimate and it is standing, we don't have a right to divorce those people. We can only probably intervene and find a resolution when the marriage was indeed fraudulent. For instance, you'll find that there were no signatures, no witnesses, and so on and so on. Then that marriage would have been null and void. But also, we must not, condemn criminality. We don't condemn people who go and hijack a vehicle or a CIT and say no because they are poor, they want access to money. Criminality is criminality. And we need to understand that those who are involved in criminality of marriages of convenience is actually criminality. We are giving access to the country to foreign nationals who have no good interest to come into the country, who actually want to enter the country through a back door. If there are marriages that must be held, those marriages must be legal, they must be for love, not for purposes of getting performance. And I think we'll have to administrate criminality and treat it as criminality where it needs to do. And I think we need a deeper conversation around those issues. But all in all, Chair, we note the responses and comments that are made by the portfolio committee. I think most of them will need to create a platform for a more deeper dive in dealing with them. Thank you.
No, thanks, DM, and thanks, DG, and all honorable members. Thanks, DDG, Meetse and Advocate Malekate, and all the issues that have been presented in this important meeting. The decision you have taken will facilitate that to ascertain clarity on certain issues that members have raised, including the Phil Craig matter, and also the judgment that is before us. I'm happy, DG, you appreciate that it's important that fast track the issue of the white paper. There's another matter that I think we may need to work out, Deputy Minister, which is important to interact with the portfolio committee. It will be advisable that when there are matters that the department want to engage on, particularly those matters that have not been outside our parameters of engagement or conversation with the committee, it will be important to update the committee before we get issues on the street. It's not wrong to post the programs, but it's important for this work that we're doing collectively with the department and the committee, that from time to time when you come to the meeting, the minister has an issue to brief the committee. So it doesn't augur well to interact with the committee in the media platform. And if that is a directive or is a approach we're going to take, it will be difficult to interact with the committee. You'll recall, members, for those that have been in the session, that the then minister ought to engage with the committee on any matter that he or is going to pronounce, including the matter that is delegated to his deputy minister. So it's important that we must maintain that decorum of a working relationship. We appreciate progress that has been made, but it's important that we're also being deposited with a brief in the portfolio committee meeting. Members, I think these are all the issues that have been dealt with, the items. and all the reports have been noted, including the matter of Honorable Mokhale on the outcome of the weekend. We congratulate you and think he wanted us to formally congratulate you, and happy birthday to Honorable Ngubane. The matter of Toyana in the Eastern Cape, it's an important matter that we must further create awareness, DG, and make sure that society understand, because sometimes these are the issues that we grapple with all over. As Honorable Machi indicated, that there are people who, when things are not going well, they bring Home Affairs into the space. But I think it's a matter that we need to create awareness, but also expose these intentions of gradually or in any other time put the Home Affairs into the negative space with the responsibility that an individual could have carried. So I think it's also a matter that we must demonstrate, and I think we're happy that you're also taking forward to assist the Metoyani on this subject matter. Members, thank you very much. If there's no any other matter, Mr. Matonsi will then step off the agenda meeting. Is there another matter, Mr. Matonsi?
No, Chair, there's no other matter.
Thank you, members. We'll step off this meeting. The meeting is adjourned.
Chairperson, thank you.
Thank you.
Thank you, Chair.
Yeah, bye-bye.
Thank you.